to direct him further. You ask him, does he run by you before you get over the right-hand lane? Do you remember?
I'm asking him a question, at which point he runs by him.
In response to which Mr. Bryan tells you he had to have.
That's correct.
Which is basically telling you he doesn't really recall.
Objection to speculation.
Sustained.
And then again on page 7, you direct Mr. Bryan again, quote, and Ahmaud has already run back this way, unquote.
That's correct. That's a question.
And then in his response, he tells you, quote, I mean, what it feels like, I mean. Those are his words. You didn't take that to reflect uncertainty as to his recollection?
From the very beginning, Mr. Bryan indicated that he would try to the best of his ability to recall what had happened 2.5 months before. I expected there to be some difficulty in trying to remember exact specific details, so it was not a surprise to me.
Okay. Now, directing your attention to, I think it's the bottom of page 7, you're asking Mr. Bryan how fast he's going as he's trying to catch up with Mr. Arbery. Do you recall that?
Yes, sir.
And Mr. Bryan answers he doesn't think he's going more than 15. You remember that?
I don't think he says that we're not going above 15. He asks me as I'm driving and we're getting to a speed, he says, yep, right about that. And I responded, and we're about 15 now, and he says, yeah.
Okay. And then you say we're going 10 right now.
That was prior to us going 15.
Okay. In the middle of the page, you ask Mr. Bryan, how fast are you going at this point? Do you see your question?
Yes, sir,
Page 7. And his response, man, I swear I don't think it was more than 15.
That's correct.
And you say, okay. So it was pretty slow.
Yes, sir.
And Mr. Bryan says, yeah. You say, okay. And then he asks, what do you got? Do you recall that question?
Yes, sir.
And so he's asking you how fast you're going at this point.
That's correct.
Because you're operating the vehicle.
Because from the very beginning, I advised Mr. Bryan to direct me as how I'm driving the vehicle as he would have driven the vehicle.
All right. And then so you answer, so we're going 10 right now.
Yes, sir.
And he says, yep, right about that. Correct?
That's correct.
He's agreeing with you. And then you say, and we're about 15 now.
Yes, sir.
And he responds, yeah.
That's correct.
At this point, he's just agreeing with what you're telling him.
No, sir. I'm asking questions to gain information, and he's answering those questions. He's not just agreeing with me the whole time.
Okay. And on page 8, without going into the details as to what you're asking him about, you asked him whether he remembers something, and he tells you, quote, no, I really don't, unquote.
He does.
Page 8.
And then later on, a few lines down, he gives a range as far as it would have happened just before I asked him.
Okay. Well, thank you for getting me to turn the page. And at this point, he tells you he thinks he remembers, or he thought he remembered something. 60% down page 8. And I'm sorry, officer, I just don't have the line numbers. He tells you, I thought I remembered. Am I correct?
That's correct.
And in that 5-line answer, can you count for me how many times he uses the word maybe?
Six times.
All right. But that didn't indicate to you any confusion on his part or uncertainty?
In the context of what we are discussing here, it does not. His focus was not on exactly what I was asking him about, so I did not expect him to be able to remember it specifically to the exact moment in time. This was Mr. Bryan's focus seemed to be on Mr. Arbery at the time, so it wasn't unusual for him to not be able to see what it was I was asking him about.
Okay. And at this point, he basically tells you that he really needs to see the video again. On the bottom third of page 9?
Page 9?
Yeah. After he said, "That will make sense, man," you ask him a question, and then at the bottom he gives you an answer, and he starts out with, "I have to look at the video again. But yeah, I think I'm trying to stay on my right side of the road because I'm quote unquote freaked out now." Do you remember that?
I do. This question is only in relation to where in the road he is with his vehicle. So his being able to determine exactly whether he was all the way to the left, all the way to the right, into the center, needing to see the video for that kind of detail is not really relevant at this point.
Because at this point in the investigation, that's not really what you're focused on.
The detail of exactly where he was in the middle of the road was not a focus of the investigation.
And you don't know whether that's become a focus 17 months later, 15 months later, because you're a witness.
As a member of the investigative team, in our discussions, I know that where exactly he was on the road at the time he took the video is not an investigative important question.
Okay. And again, directing your attention down to hold on, I'm not ready to go there yet. And again, on page 8, your question to him is, it was either here or up here, but you remember something about traction. You remember asking that question?
Yes, sir, I do.
Because while in some respects you've told the jury that details aren't important, this detail matters to you, doesn't it?
Only to the extent that I'm trying to get him to provide the most information that he can from his memory. This question only refers to the point where he does the 3-point turn in the reenactment that we showed, where he comes back out. There was 2 areas that it most likely occurred in, and that's all we were trying to determine.
Okay. Well, in the practice run, in the dress rehearsal for this, you were suggesting to Mr. Bryan that he had driven to the top of the street before turning around. You don't recall that?
No, sir.
Because that would affect how fast Mr. Bryan had to be traveling, wouldn't it?
I don't know.
Well, you know the length of the video, right?
Yes, sir, I do.
So if you can figure out where the video starts and where it stops and the number of seconds that elapse, you can get some idea of how fast things are happening. Am I correct?
I could, but if I was directing Mr. Bryan on what to do, I would have directed them to go all the way to the end of the road before we did a turnaround in the reenactment. But his memory was that he did not go down that far, and he was trying to determine which area he pulled into to do the turnaround prior to going to the end of the road.
Well, you'd agree it'd be a whole lot easier to figure out how much leading is going on here and how much direction and how much uncertainty there is if we had recorded the dress rehearsal as well.
No, sir.
Now, you asked Mr. Bryan again about a black mailbox on page 9.
That's correct, yes, sir.
Because the black mailbox matters to you.
The black mailbox is simply a reference point during the video of when he picks the phone back up, as I indicated while we watched the reenactment video.
And Mr. Bryan again indicates to you that he really doesn't recall.
That's
He's
correct.
not in the top 40% of page 9?
Yes, sir, he states that will make sense.
And then on page 10, you're directing Mr. Roddy to tell you where he thinks he stopped prior to the shooting.
Are you talking about the second line?
Yeah, are we where you stopped and parked? Are you closer?
That's not direction, that's a question. It starts with, are we? I'm asking Mr. Bryan where he thinks he is, or if we are at the location where he stopped.
And Mr. Bryan tells you, I think I'm going to be a little closer.
He actually starts off and confirms and says, yeah, and then says, I think I'm going to be a little bit closer. I think when we left the scene, I backed into the driveway.
Okay. So he's telling you he's even closer to the shooter.
I'm sorry?
So he told you he was closer to the shooter, or probably closer to the shooter.
From where we were at the point in the drive-through, he was saying he was a little bit closer than where I had initially stopped and asked him that question.
And that's because Mr. Bryan is trying to minimize his involvement in this case. He's trying to distance himself from the shooting when he tells you that he's probably closer.
Mr. Bryan's involvement or minimization in the shooting has nothing to do with where he is at the time he stops and finishes recording. His minimization had occurred earlier in the process of chasing Mr. Arbery out of his driveway.
Okay, well, we'll come back to that. And then you say this is, quote unquote, kind of where you take that final video of the shots.
That's correct.
And he says, I'd say, quote unquote, probably about right there.
After he directed me by saying, I'd say a tad more up front, indicating for me to pull forward a little bit. And then he says, I'd say probably be right about there.
Okay. And then Roddy says at the bottom of page 10, quote unquote, I'm guessing here, man.
That's correct.
And again on page 11, again on where he is, Mr. Bryan tells you, I don't know. I don't recall exactly, but I want to say not until I stopped. I'm sorry. When you ask him about when he first saw the gun, when he first saw a firearm, what does he tell you?
I don't know. I don't recall exactly, but I want to say not until I stopped.
All right. Hopefully no more transcripts this morning.
Okay.
My next question is this. Regardless of what Roddy Bryan told you or said to anybody else in the months before, we know that Mr. Bryan walked to his garage to get his keys, don't we?
I don't recall the video specifically. He didn't run, but if it was walk, it was a quick walk.
Okay. Because you can count the number of seconds on the video, all right?
You could.
Okay. And when you do that, he's obviously not running.
I'd agree.
Okay. So if he told somebody he was running, that would have been incorrect.
I agree.
Okay. And we know that Mr. Bryan, whatever he may have said to someone over the months before, we know from the night out video that he walked to his truck.
That's correct.
Now, and let me be clear, you've reviewed the night hour video. I mean, I know that, but I have to ask.
Yes, sir, I have.
Okay. However, Mr. Brody described the position of his truck in his driveway over the course of many interviews and over several months. Whether he said straight or to the left or towards the right, we know from the night owl video that he's angled, your word, not mine, for lack of a better word, to the right and away from Mr. Arbery as Mr. Arbery is coming back to his house.
Your Honor, I'm going to object to any testimony about the night owl video's contents because the video itself will be the best evidence of that, and that video will come out in the evidence.
That's fine. Okay, go ahead.
But some things are clear in this case from your investigation. As Mr. Arbery passed Mr. Bryan's house, did Mr. Bryan tell you that Mr. Arbery called out to him, please call 911, there are crazy people after me?
No, sir.
Roddy Bryan told you that Mr. Arbery never said a word.
That's correct.
I believe Roddy Bryan told you that he never saw Mr. Arbery's lips moving.
I don't remember those words exactly, but he did say that Mr. Arbery never said anything during the entire incident.
Well, going back to your May 13th statement, although Mr. Bryan has said in various contexts that he heard the person in the truck speaking, when you interviewed him, it was clear that Mr. Bryan was really reading lips at that point.
I don't recall that.
You don't recall him talking about the driver of the truck's lips moving?
Not offhand, no, sir.
And he couldn't see Mr. Arbery's lips moving because Mr. Arbery's face was not directed towards him. You don't remember any of that?
Is that a question?
Yeah, it was a question.
I don't remember speaking specifically as to whether or not he could see Mr. Arbery's face to see his lips moving or not.
Okay. Now, I believe you've, did Mr. Bryan report Mr. Arbery as he's passing in front of his home making any gestures toward him? Like, help?
No, sir.
Okay. Now, Mr. Bryan is out on his front porch at this point, right?
That's correct.
And music is playing.
Yes, sir.
And the closer Mr. Bryan gets to the garage, the louder that music gets.
I would say that's believable. Yes, sir.
Because that's where he told you the music was coming from.
Yes, sir.
Okay. His garage door is open.
That's correct.
Okay. And his driveway is parked out in the front on the driveway, right?
His truck?
Yeah.
That's correct.
What, if anything, had Roddy Bryan done at this point to convey to Mr. Arbery any hostile intent?
I don't know that Mr. Arbery would have even seen Mr. Bryan at this point.
Well, we can speculate as to what he saw or didn't see. But what I'm saying is, from the person vantage point of Mr. Arbery on the street, there's a white dude working on his front porch with the car in front and the garage door open and music playing, right?
That's correct.
Is there anything else about that scene to suggest that Mr. Bryan bears any ill will or hostile intent towards this gentleman?
I'm not sure what you're asking.
Well, I'm trying to figure out who's jumping to assumptions here. It feels like from the statement you obtained from Mr. Bryan that it's Mr. Arbery who's assuming the worst about Mr. Bryan.
And I'm going to object to that, Judge, as speculation.
I'll rephrase.
Good question out there, please.
What, if anything, from the point where Mr. Arbery comes to his front yard, passing one set of bushes, crossing across the driveway, and out of view to the other set of bushes, in that time frame, which is on the Night Owl video, but as to which you've interviewed Mr. Bryan, what, if anything, does Mr. Bryan do? What, if anything, does Mr. Bryan say? What, if anything, does that picture suggest to Mr. Arbery that he could not seek help?
In Mr. Bryan's statement, he actually says that he hollers out to the truck, y'all got him, or you need help. So to me, that would indicate, and he indicates that he is speaking to the truck. So that to me would indicate that he was not there to help Mr. Arbery.
And he's also indicated to you that it was obvious from the circumstances that nobody could hear him.
We don't know that. He thinks that nobody could hear him because his music was playing. But you're asking me, what would have Mr. Arbery have seen from the road? Now, we don't know what Mr. Arbery would have heard, but needless to say, his words were directed to the truck as, do y'all have them or do you need any help?
Okay. Do you recall from your interview with Mr. Bryan ever saying that Arbery asked him to call 911?
No, sir.
From Mr. Bryan's perspective, the events of February 23rd are, for a lack of a better term, chaotic. Would you not agree?
Objection, speculation about Mr. Bryan's perspective, Your Honor.
Well, you asked Mr. Bryan what he was doing that day and what he knew. Am I correct?
I did.
And Mr. Bryan indicated to you he wasn't in communication with anyone that day.
That's correct.
Specifically, he wasn't in communication with Matthew Albenzi.
That's correct.
He doesn't know anything about Matthew Albenzi, does he?
That's correct.
He can't because Mr. Albenzi is well up the street.
That's correct.
Okay. And you reviewed Mr. Bryan's cell phone records. You reviewed his social media. At this point, you probably know more. You may know Mr. Bryan better than Mr. Bryan knows himself. Fair enough?
I don't know if I go that far, but
Mr. Bryan is not in communication with anyone prior to the shooting.
that's correct.
He doesn't know whether Mr. Albenzi is armed.
I don't know that I ever asked about Mr. Albenzi and what Mr. Bryan knew about him.
And Mr. Bryan doesn't know that the McMichaels are armed until moments before the shooting. That's what he told me.
That's correct.
Matter of fact, Mr. Bryan doesn't even remember seeing Gregory McMichael until after the shooting, when you can see him clearly on the video in the back of the truck.
That's correct.
And Mr. Bryan's told you that several minutes elapsed before the police arrived on the scene, when we know that, in fact, it was probably a matter of seconds.
That's correct.
Mr. Bryan has told you at times that he feels like he's alone out there with Mr. Arbery.
Yes, sir. After he cuts him off, tries to block him in, he says he realizes he's with him by himself.
Okay. And when he's quote unquote cornering Mr. Arbery, he's doing that by himself.
That's correct.
And even after Mr. Bryan gets so many facts about this case wrong, facts that we can actually see on the video, you're still surprised that he struggles to recall minute details months later?
I don't think Mr. Bryan got a lot of facts incorrect. I think the general facts of the case, he was correct in his recollections. What he was incorrect on or unsure about were what I would call minor details, like I said, positioning of the road and that sort of thing. Now, if we're talking about Mr. Gregory McMichael and his remembrance of him in the truck, it's not uncommon for witnesses in traumatic events or people that see traumatic events to somehow get what's called tunnel vision, and they might miss certain aspects of an event. That's why anybody that sees any type of traumatic event, if it's multiple people, you can ask them, and they'll all see something a little bit different. And that's how I would explain Mr. Bryan's recollection.
And Mr. Bryan's basically related to you without using the words that this was a traumatic event for him.
It was.
And you can hear in his breathing the fear during this encounter.
I don't recall hearing his breathing.
How many times have you listened to this video?
More times than I'd like to remember.
You and me both, but you don't recall that.
No, sir.
Okay. Now, Mr. Bryan told you why he didn't call 911. Am I correct?
Is there a transcript?
Directing your attention to page 101 of the, I think it's the May 13th transcript.
I don't have it up.
Which,
Yeah.
I spoke too soon. I'm sorry. Directing your attention to the top or the bottom half of page 101 of the May 13 transcripts.
Yes, sir. Mr. Bryan states that he thought somebody had already called the police.
And in fact, however big an assumption that might have been, he was correct.
Objection, Judge, the speculation about him being correct.
I'll rephrase. In fact, Mr. Albenzi had called the police,
That's correct.
and that would have been before Mr. Arbery ran by Mr. Bryan's house.
That's correct.
And is it fair to say that the first crime that Mr. Bryan saw that day, personally witnessed, would be Mr. Arbery trying to get in his truck?
Unless you discount the fact that somebody was trying to chase Mr. Arbery down while he was legally running, jogging down the road.
Well, obviously from Mr. Bryan's perspective, I'm not asking you what's going on in Mr. Arbery's mind, but from Mr. Bryan's perspective, the first actual identifiable crime that Mr. Bryan sees is when Mr. Arbery is trying to get in his truck.
Objection to speculation, Your Honor.
I'll move on. And it's fair to say that at the time that Mr. Bryan has told you that Mr. Arbery is trying to get in his truck, that at that point Mr. Bryan is somewhat preoccupied.
Preoccupied how?
Well, he's trying to pull his vehicle away so that Mr. Arbery, that's what he told you, he's trying to pull away. The fastest he's traveled the whole time is to create distance between himself and Mr. Arbery.
If Mr. Bryan was that concerned and scared about Mr. Arbery, he never would have angled to the left onto that driveway to try to box him off or cut him off to begin with. If Mr. Bryan was truly concerned about his safety with Mr. Arbery, he would have stayed to the right side of the road and stayed ahead instead of turning off to the angling to the left to box him in.
Okay. Well, thank you for that answer. But getting back to the issue of Mr. Bryan calling 911, at the time that Mr. Arbery's prints are on the side of his car and that he's told you that he's trying to come in the door, is it fair to describe Mr. Bryan at that point as being somewhat preoccupied?
Preoccupied with trying to chase down Mr. Arbery, hence him coming out of the driveway like he did and following him through the ditch or next to the ditch and then up next to the tree. I would say yes, he was preoccupied.
I'm sorry. Again, directing your attention back to the 911 call, or the lack thereof. You're not trying to suggest to the jury, notwithstanding all this other stuff you want to talk about, you're not trying to deny that it was impractical for Mr. Bryan to call 911 literally while Mr. Arbery is attempting to get in his truck.
At the exact moment that that is happening, probably not. But there were moments before and there were plenty of moments after where he could have made that phone call.
And that's obvious from the video, right?
It is.
Okay. And again, directing your attention to page 101, Mr. Bryan expressed regret to you over Mr. Arbery's death.
He did.
Okay. And in fact, he told you. Whether that was for whatever reason, he said that he wished he had stayed on his front porch.
That's correct.
Okay. Now, because it's come up, yeah, it may come up again. After Mr. Arbery and this white truck are going off screen, Mr. Bryan goes in his house. Am I correct? We see him on the video going in his house. He tells you he goes in the house.
That's correct.
Okay. He goes inside his house to get, what did he tell you went inside to get?
His keys.
Now, at the time that Mr. Arbery goes by his house, Mr. Bryan already has a weapon handy, doesn't he?
I don't recall specifically.
You don't recall in the Night Owl video the hammer laying on the front porch next to where he's holding the board that he's trying to put up on his front porch?
Not offhand.
Okay. You don't recall asking him about the hammer?
I don't.
Okay. But in the video, you can see that Mr. Bryan, when he walks to the garage, he's not carrying anything.
That's correct.
He's left his hammer, he's left all his tools behind.
Yes, sir. That's correct.
And he's gone in the house to get his keys, correct?
That's correct.
Okay. Mr. Bryan leaves his gun, his rifle, inside the house.
Yes, inside the back bedroom, I would say a good distance from where his car keys were located.
Mr. Bryan doesn't own a handgun, am I correct?
From his statements, that's correct.
Well, you subsequently checked, did you not?
There's no way to check if somebody owns a handgun necessarily.
Okay, but you can check registrations.
There's no registration in the state of Georgia. You can find a purchase through the ATF, but there's no formal registration for firearms.
Did ATF records ever show that Mr. Bryan purchased a handgun?
We didn't check ATF records. Typically, in my experience with ATF, you have to have a firearm and serial number to run the check. You can't just do it off of a name.
Okay. And where's Mr. Bryan's rifle today?
I have not checked the evidence receipts to know the exact location, but if it's where it was, where I'm guessing you're going with this, it's in our custody.
Okay. Did you ask for, or to your knowledge, was any forensic examination conducted of this firearm?
I was not in charge of testing evidence or determining evidence that would go to the lab.
The reason none of this is being done is because it was obvious that Mr. Bryan, when he tells you that he was unarmed that day, it's obvious that he was unarmed.
I believe that's correct. Yes, sir.
And believe it or not, I have no further questions for you. Thank you so much for your time.
Thank you.
Anything from the remaining defendants?
Not from Travis McMichael.
No questions. Any redirect?
Yes, Your Honor.
Agent Seacrest, Mr. Goff asked you about Mr. Bryan expressing regret in your May 13th interview with him. You remember that?
Yes, yes, ma'am.
So just to be clear, that was 3 months after the incident, right?
That's correct.
And that was after the McMichaels had already been arrested.
That's correct.
Okay. And that was after the media got a hold of the video and it became this big thing.
That's correct.
That he's expressing regret.
Yes, ma'am.
Okay. I don't know if you remember, it's been a weekend, but on Friday, Mr. Goff asked you about all this media presence and maybe threats that the defendant had been getting, or his fiance. You remember that?
I do.
Okay. At any point, did you, Agent Seacrest, use any of those, protests or supposed threats to influence Mr. Bryan into giving you a statement?
Absolutely not.
Okay. Did you use that to your advantage in any way?
No, ma'am.
Okay. So you also testified that you wanted to look at this case with a pair of fresh eyes. You remember testifying to that?
Yes, ma'am.
When Mr. Goff was asking you about why you noted Mr. Bryan as a witness in the May 11th interview?
Yes, ma'am.
Okay. Have you reviewed Officer Minshew's body cam interview with Mr. Bryan?
I have.
Okay. Have you reviewed Investigator Lowry's recorded interview with Mr. Bryan?
I have.
Okay. Were you able to pinpoint how many actual minutes or hours of interview time, meaning actual speaking, was going on in those two interviews?
If you were to take off called dead air time where nothing's being said, or Mr. Bryan was just sitting in the room by himself, the interview with Detective Lowry was approximately actually 20 minutes long, and the first part of that was really just filling out a consent form. I don't recall the exact amount of time for Deputy Minshew on scene, but it was not very long, and a large portion of it, or I shouldn't say large, a significant portion of it was trying to figure out the video and how to get it emailed to an investigator, and then the substantive part of the interview was very spatial. He went down here, he went this way, and so it's hard to tell from watching the video. So overall, I would say by far less than 30 minutes of interview time with Mr. Bryan by the time that we got the case.
Okay. And for your 2 interviews with him, and counting the reenactment video, about how many hours did you spend with Mr. Bryan?
Overall, it'll be approximately 5 hours or more.
Okay. Compared to the 30 minutes you said with Glenn County PD?
That's correct.
Okay. Now, is that what you meant when you said you wanted to look at it with a fresh pair of eyes?
Yes, ma'am, it is.
Okay. And did you then go ahead and look, okay, how does this match up to what he told Glenn County PD?
Yes, ma'am.
Was that important to your investigation?
Very important.
Okay. That's all I have. Thank you.
Mr. Goff, anything on those matters?
Yes, Your Honor. The media influence that was out there from May 11th to May 13th, whether you created it or not, it was there.
It was there.
You were certainly aware of it.
I was aware that the media had spotlighted this story, yes.
And whether you did it or not, it was your agency that gave the press conference. You testified Friday. You were there as your boss was talking about this case to the media.
I was there.
Okay. Now, obviously, you don't tell the GBI director how to run investigations. Am I correct?
That's correct.
But there's no mistake that your agency did play a role. We could quibble over how big a role, but played a role in that media storm.
By role, there would be different roles that somebody would play. In this case, though, we were not the driver of that media. We were simply responding to the media requests.
All right. Now, you've indicated that you went back and tried to estimate the length of other interviews.
Yes, sir.
Is transcript length one indication of how long an interview is?
It could be.
Okay. Well, directing your attention to, every time I think I'm done with transcripts, they keep coming back. Directing your attention to your May 11th, the transcript of your May 11th conversation with Mr. Bryan. How long is that transcript?
In pages, it is 105 pages, 106 pages.
And directing your attention, you can give that one back, and we're going to trade out, okay? I'm going to give you the May 13th transcript. And how long is that transcript, sir?
103 pages.
All right. And those transcripts cover almost 4 hours?
Yes, sir.
Okay. And you've indicated you reviewed the transcript of the Minshew body cam.
That's correct.
And that's approximately 54 pages.
I don't recall specifically, but
We are.
On the side.
Miss Olivia. Are you sure it's transcript?
Should be, the copies that were on the tender.
My apologies, Your Honor, I'm trying to find tender documents.
Unless someone reads them. Let's see. Here's the 23rd one.
Okay.
Okay. Minshew body cam, it's right here. Okay. Just put it back whenever you're done. Okay.
Sir, directing your attention to Exhibit 195A. That's the Lowry interview transcript.
Yes, sir.
How many pages is that?
20 pages.
All right. And directing your attention to 228A, the Minshew body cam video. Can you tell me how many pages that is?
52 pages.
52 pages.
The difference with the Minshew body cam video, though, is there's much more in here than just the
Sure.
interview with Mr. Bryan. It also includes conversations between officers, with dispatch overheard in the background, so it's more than just the interview.
Indeed. Thank you, sir.
You're welcome.
Would you not agree, Agent Sechrist, that the length of an interview and the length of the discussion are not directly related?
I would agree.
Other officers covered the same subjects that you covered. They may have done so quickly, but they covered the same ground, did they not?
We covered the same ground as it related to the facts, but I would say my interviews dealt more into detail regarding some before and after the fact, and also some more specific questions during the incident. But the same set of facts, yes.
Well, there's no question. You are, do you know any police officers who are more thorough than you are?
Yes, sir, I do.
You do?
I do.
Okay. All right. Is it fair to say you consider yourself a thorough police officer?
That's my goal.
Okay. All right. Fair enough. Now, in the Minshew body cam video, Mr. Bryan goes back over the events 3 times?
I don't recall specifically, but I'll go
Something
with
like
it.
that? And
Yeah.
Lowry at least twice?
I don't recall those specifics. So.
And you read the entire Glenn County Police report, haven't you?
I have not.
Oh, okay. So you don't know how many other interviews took place that weren't recorded, such as by Detective Lowry on the scene?
I'm not aware.
Okay. Now, in any of the statements that you've reviewed that Mr. Bryan has ever made, he's adamantly denied having a firearm at any point on this day.
That's correct.
Okay. And certainly if Mr. Bryan were brandishing a rifle in his pickup truck while he's taking a video, how many hands does Mr. Bryan have?
2.
Kind of hard to hold a gun, hold the steering wheel, and move a car while you're taking a video.
That's correct.
There's no doubt that whatever other people in this case may have done, Mr. Bryan came out there armed only with his cell phone.
And his vehicle.
Okay. All right. Thank you, sir.
You're welcome.
All right. Thank you, Agent. You may step down. Yeah, I want you to just leave them up there. I'm not sure whose transcripts those are and whether they're exhibits or not. Agent, you are, you're free to go, but you are subject to recall. Yes. Thank you. My thought is to get started.
May we have a courtesy break at this time, Your Honor?
Okay, or we can do that. All right, ladies and gentlemen, let's go ahead and take a 15-minute recess, and we'll get back to the evidence in just a moment. Thank you.
It's all right for a jury. Be seated.
All right, let's take 15 minutes. We're in recess. Be seated. All right, we are back on defendants present. Got two lawyers up. I assume you're calling your witness, or is there something for the court?
It's something for the court, Your Honor.
Okay. From the state first, I'll work around.
Thank you, Judge. Your Honor, the next set of witnesses are lay witnesses, and the state filed its brief 4.72 on October 18th of 2021. These witnesses are in no way character witnesses about Ahmaud Arbery. These witnesses are intended specifically by the state to provide facts about their knowledge of Mr. Arbery and that he was an avid runner. The defense has been beating a drum repeatedly that the state is going to open the door by putting these witnesses up, and that the state will somehow inadvertently do something that would cause the defense to be able to walk through that door. And out of an abundance of caution, I filed this brief just to make sure that we were all on the same page, because I don't know what cross-examination questions are going to be asked of regular people, and I don't know what their responses are going to be to cross-examination questions. So I just wanted it on the record. And this is, of course, per Montgomery versus the state, 350 Georgia App 244, a 2019 case about the way to handle non-responsive answers from witnesses who may inadvertently say something that the other side considers to be good character evidence. And in that particular case, they said the party has to have the intention to put this person up as a character witness, and the other side does not get to go, gotcha, and put in evidence that's been excluded simply because of that. In addition, in Strong versus the state, 309 Georgia 295, a 2020 case, if inadmissible evidence were to come in, the opposing party must object, because you can't just consent to, well, inadmissible evidence came in and I didn't object to it, now I get to put in additional inadmissible evidence. And that is what the Strong case held. So, Your Honor, we have no intention of eliciting reputation or opinion testimony or good character testimony at all from these witnesses. They are strictly fact witnesses. And the reason they're fact witnesses, and this is a relevant issue, is because the defense has put in evidence that Mr. Arbery walked into the neighborhood. They have not conceded in any way that he was a runner and or a jogger. This is now, because of the defense and their openings and the way they presented this evidence, an issue in dispute. So at this time, we feel it's relevant that he was, in fact, a runner slash jogger. We're not intending to elicit why he did these things or what they were for. It's just a fact that he was that person. And so we just direct you to our brief. If this were to become an issue, we do not wish it to be, and we don't anticipate that happening. But once again, these are non-law enforcement regular folks who are going to be taking the stand now. Thank you, Judge.
Good morning, Your Honor. So I thought the court had ruled pre-trial that Mr. Arbery's intent in the neighborhood that day was not a matter before the jury and was not relevant. We didn't put in evidence that Mr. Arbery walked in the neighborhood. The state did. So I thought we weren't getting into Mr. Arbery's intent in the neighborhood that day, Mr. Arbery's intent in the house that day. The court forbid us from putting in evidence about those things. So what's the relevance of the state's witnesses to say that he's a jogger? The court's already ruled that's irrelevant. Now, any witness that testifies will be subject to cross-examination. I'm not going to trick a witness into answering questions that open the door. I understand how the law works, but I don't see the relevance here. where the court has specifically said his intent in the neighborhood that day is irrelevant to this trial.
Mr. Hogue.
Your Honor, just to adopt the argument made by Travis McMichael's attorney on behalf of Greg McMichael, I do so now. And just add it into it a couple of corrections. We've not argued that Ahmaud Arbery walked into the Satilla Shores neighborhood. What we've argued is that the state introduced a video that shows him walking into the yard and up to the house at 220 Satilla Drive. He may have walked into the neighborhood and walked to the house. He may have run into the neighborhood, but the video we have is of him walking down the street and then into the yard and into the house. And that's the first one. The second response to his being an avid runner or jogger, it's logically true that he could be both an avid runner and avid jogger. In fact, we don't have any reason to dispute that. But that on some occasions, when he engages in the activity we call running or jogging, he's doing it for other motives besides physical, mental health, or whatever other reasons a runner would run. And we've offered those before. I made an argument here, seems like a month ago, but it was probably 2 weeks ago. And it goes to this issue, and then I'm done. The state says, by offering this evidence, this is an answer to why was he running on 2/23/20. I mean, the evidence is meant to allow an inference to be made in argument that on this occasion, on that day, his motivation for running is the same one as on many other days when he ran for mental health or physical health. And we have some evidence that so far we've not been allowed to introduce to suggest, well, there may be a different answer to that why question than the one the state wants to argue from the inference they'll make that he's an avid jogger on other days, therefore he was jogging on this day. Under 401, it's simply not relevant. And if it's a balance test under 403, then it ought to open the door to the defense at least to offer an alternative explanation for it.
Mr. Shaw.
Your Honor, we join in the motion as made by Mr. Sheffield and in the further response by Mr. Hogue.
All right, let me do this because I have my, I don't remember a formal response coming in from the defendants that was more of an advisory brief that was submitted, correct?
You mean what the state wrote?
Correct.
I think the state was just trying to identify this issue could come up. We did not respond with our own.
Except we did file motions regarding the admissibility of Mr. Arbery's being on probation as the alternative explanation for his running. So in a way, we did respond.
Addressed just before trial. Yes.
And I do believe there was a filed response to this issue concerning 404B character and whether or not the introduction of what was going on in Ahmaud's mind and speculation about why he was in Satilla Shores can't come in because, for the same reasons that the court would not allow the 404B evidence of the defense in, because the argument of the state has always been and the court's conclusion has always been what Ahmaud Arbery was thinking that day is not relevant in this case.
Let me, I can take a short recess. Let me look at what I have. I've got a notebook in the back with all the submissions. I just want to make sure I'm clear on what I have and based on the arguments made here, come back with a ruling. All right, we're in recess, hopefully very brief.
Please be seated.
All right, we're back on. Defendants are all present. All right, I took another look at 4.72, which is the brief that the state had filed on character witnesses and opening the door in consideration of what I have heard this morning. So I do have a question before I get too much further. The brief that was submitted indicates that these lay witnesses that the state intends to present, and I will read from 4.72. State's anticipating the lay witnesses who knew Mr. Arbery personally or who saw him running or jogging in his neighborhood or in the surrounding neighborhoods in Brunswick, Georgia. What is the proffer on these lay witnesses? Are we talking about just generally running, or are we talking about in Satilla Shores? What? I need something more specific.
Yes, Judge, at this time, Ms. Olivier will give you a proffer for the 4 witnesses we intend to tender.
Your Honor, the first one, Ms. Flowers, she should testify that she has seen him running in the Fancy Bluff, Boykin Ridge area, which is where he lived. She also saw him running on Highway 17, which is the highway that separates Satilla Shores and Royal Oaks from that Fancy Bluff area. So in that area surrounding Satilla Shores.
Anything more than that? Time of day, whereabouts on 17?
He would run all day, you know, during the day. Also, she's seen him during the nighttime hours. She's also seen him on Highway 303, which is also called, I believe, Blythe Island Road. So night, daytime, she's seen him all times, Judge. And she will also get into the clothing that he would wear when he runs. And I think that's about it for her. We intend to tender the in-life photo through her as well. And I don't know if the court has a question for me before I move on to the other ones.
No, go ahead.
Okay, so Linda Randall, she lives on Andy Tottenson Road. She's gonna testify that she also saw him running in that neighborhood, and he would run for long periods of time. And the way he would be coming in terms of the direction, in addition to the timing, she would say that he would probably be running out past Highway 17 in that Satilla Shores, Royal Oaks area as well.
Sorry, and he would probably be running in the area past Highway 17.
Highway 17 and across the highway to the Satilla Shores, Royal Oaks area.
That she had direct knowledge of it, or she
saw him.
She saw him run across the road?
On Highway 17.
Yes, so she saw him the way her house is positioned. She would see him going and then coming back that direction where the entrance to Highway 17 is. Danielle Stoddard will testify that, similarly, Judge, that she saw him in her neighborhood, Fancy Bluff neighborhood, and she would also see him around that Highway 17 area when she would be bringing her kids back from school. And Ashley Wittenberg, she will testify that she saw Ahmaud running in the Boykin Ridge neighborhood, that she would see him running at night when it's dark, which of course is an issue in this case because we have the defense attorneys saying, you know, he's in Mr. English's construction site at nighttime. What could he be possibly, you know, doing there? So she'll testify to the nighttime running as well. And those are all the witnesses we have to testify on that subject. Okay.
Well, I'll tell you, at this point in the evidence, what I have got in my notes is that the issues that have been raised, I think the first one was through, I think it's Miss Parr, maybe her parents were the Parrs, but Miss Parr. She was asked specifically by the defense about whether or not she had seen Mr. Arbery running in the neighborhood. Mr. Albenze was also asked about whether or not he had seen Mr. Arbery running in the neighborhood. I have not heard the questions asked, but based on the proffer, the court's concern is that none of these witnesses are actually testifying or rebutting any evidence that has been brought out by the defense. And the evidence itself would require one to make that logical leap that the court's concerned about with other evidence on why Mr. Arbery was in the neighborhood at the time. They don't actually place him in the neighborhood at any time. So again, the court's, if I'm being asked for a ruling without hearing the evidence, the court is indicating that if this is the type of evidence that comes out, at least in the state's case in chief, depending on how it's worded, it may end up opening the door to the why question that I have addressed in other orders of this court. Now, whether it has to come, whether this comes out as rebuttal at some point, it really depends on the evidence presented. Because again, what I have heard is that there is evidence from witnesses that was elicited by the defense that witnesses did not see him running actually in Satilla Shores. There are other questions here that sounds like are out there, like what clothes he wore when he ran. That is not something that has been brought out at this point, as I recall, as far as evidence or argument. The time of day, the times of day, I guess, that are involved in the various incidents that are before the court. So this could be rebuttal, but as far as the state's case in chief, strikes me as this gets us to the why question.
Understood, Your Honor. At this time, we will then just call Carol Flowers solely for the in-life photo, and having discussed that at the break with defense that may be your ruling, we understand where the defense is going to go with Ms. Flowers and where we're going to go with Ms. Flowers. So if we may have 5 minutes just to make sure we're on the same page as a team, we'll go ahead and do that.
Let's take a 5-minute recess.
Thank you, Judge.
Be seated.
All right, we're back on defense president, represented by counsel, Mr. Goff.
Yes, Your Honor, I have a motion to make. This time we would ask that the Honorable Reverend Jesse Jackson, who I believe is still here, of course, he is, Your Honor, I think we all know, an icon in the civil rights movement. Not just a witness to it, he is the personification of it. And in other circumstances, I think everybody would be happy to have their picture taken, maybe get an autograph. But in the context of this trial, we object to his presence in the public gallery inside the courtroom. We note that there is a jury assembly room capable of holding, depending on how we socially distance, several hundred people, where these proceedings are being televised live in real time. The issue that Ray brought up previously is how many pastors does the Arbery family have? We had the Reverend Al Sharpton here earlier, last week, and I'm not keeping track, and I think the court has indicated the court doesn't intend to ask anyone to keep track of who was in the gallery. But I don't know who Mr. Jackson, Reverend Jackson, is pastoring here. My understanding is, and I was given names, that the Arbery family have local pastors. They also have attorneys. Mr. Arbery, Marcus, has a team of lawyers to comfort him through these proceedings. Certainly, Ms. Cooper has been amply comforted by her legal counsel. And we are concerned about whether it's conscious or unconscious, the impact of their presence with respect to the jury and with respect to the proceedings in this case. And I guess the next question is, which pastor is next? Is Raphael Warnock going to be the next person appearing this afternoon? We don't know. Your Honor, I would submit, with all respect to the Reverend Jesse Jackson, that this is no different than bringing in police officers or uniformed prison guards in a small town where a young black man has been accused of assaulting a law enforcement officer or corrections officer. As I have noted before, the city of Brunswick is indeed a fishbowl. Your Honor, I understand that the court, maybe I misunderstood the court the other day, but I think the court had indicated it was the court's understanding or assumption that the Arbery family is giving up seats in the public gallery so that these gentlemen may be present. With all due respect, Your Honor, the seats in the public gallery of a courtroom are not like courtside seats at a Lakers game. There are no First Amendment rights in the public gallery of a courtroom. There is no standing of any particular individual to be present in the public gallery of a courtroom. And there is no reason for these prominent icons in the civil rights movement to be here. This is a case that has been postured in the media, I believe, by Marcus Arbery's attorney, Benjamin Crump, if not Lee Merritt, and certainly reported by the media as a quote-unquote test case for where the civil rights movement is in 2021. So with all due respect, I would suggest, whether it's intended or not, that inevitably a juror is going to be influenced by their presence in this courtroom. And while there seems to be some argument over how much the jurors can see, and I can certainly supplement the record, but I took pictures last week, and it is very clear that most of the jurors have a complete unobstructed view of the entire gallery. And again, we are concerned about our client's right to have a fair trial and the impact of the presence of these individuals is going to have on this case. And we are asking the court, and again, with all respect to the Honorable Reverend Jesse Jackson, that he be observing these proceedings from the jury assembly room where they are being streamed live, rather than sitting here in the courtroom where he can visually interact with the jurors in this case.
Anything from the remaining defendants?
Your Honor.
No.
Anything from the state?
No, Your Honor.
All right. Mr. Goff, at this point, I'm not exactly sure what you're doing. I have already ruled on this court's position with regard to the gallery. And with all candor, I was not even aware that Reverend Jackson was in the courtroom until you started your motion. I have indicated the court's position. The court's position hasn't changed. At this point, it's almost as if you're just trying to continue this for purposes other than just bringing it to the court's attention. And I find that objectionable from the court standpoint. I have said over and over and over in this trial that I am attempting to ensure that in this courtroom that the defendants receive a fair trial, and I will continue to do that. I have heard the objection. I have ruled previously on my position with regard to the gallery, and that is unchanged.
And I'm not questioning the court's ruling, but the court,
I'm done talking about it, Mr. Goff. I've heard the motion. I understand what your position is, and if it's simply just to point out that an individual is in the gallery, it has been done.
do I understand that I'm not to do that not to do that again?
I'm telling you that the court's position has remained the court's position, and unless anyone in the gallery is disruptive or here to cause some demonstration that will distract from the presentation of evidence in this case, the court is not going to single out any particular individual or group of individual as not being allowed to be in this courtroom as a member of the public. That is consistent with my prior ruling and will remain the ruling of the court. If there's a disruption, you're more than welcome to call that to my attention. If there's a problem, call that to my attention. But on this particular issue that you brought up previously, which has now been effectively renewed, I think I've been very clear we do not need to discuss it any further.
And I've been very clear of my desire to make a record. And thank you, Your Honor.
Is the state ready to proceed?
Yes, Your Honor.
All right, let's go ahead and get the panel.
All right for the jury. Please be seated.
All right, welcome back. We are ready to proceed with the evidence in this case. State ready with its next witness.
State's ready. State calls Carol Flowers, Judge.
Swear to tell the truth, whole truth, and nothing but the truth.
I do.
Go ahead and have a seat.
And I will try to shout. Good morning, Ms. Flowers.
Good morning.
Can you go ahead and introduce yourself to the jury? Just tell them your name and then spell it for the court reporter, please.
Carol Flowers, Carol Flowers.
Okay, and how are you today?
I'm good.
Good, good. So, do you live in Brunswick?
I do.
Okay. What part of town do you live in?
Boykin Ridge.
Okay, that Boykin Ridge area?
Yes.
Okay. Is that close to like the Fancy Bluff area?
Yes.
Okay. And are you married, single?
I'm married.
Okay. Do you have any children?
I do. I have 2 biological children and 1 stepdaughter.
Okay. How old are your kids?
28, 24, and 19.
Grown kids?
Grown kids.
Okay. And what do you do for a living, Ms. Flowers?
I'm a nurse.
Okay. I want to turn your attention to a person by the name of Ahmaud Arbery. Did you know that person?
Yes.
Okay. Can you tell us how you knew him?
He was my neighbor.
Okay. Are we talking like next door neighbor?
Yes. Right
Okay.
next door.
Right next door. Okay. Do you remember when you first met him?
In late 2011 or early 2012.
Okay. May I approach, Your Honor?
Yes.
All right, Ms. Flowers, I am approaching you with what has been marked for identification purposes as State's Exhibit 1. If you can look at that and just tell me if you recognize it.
Yes.
Okay, who's that depicted in the picture?
Quiz.
Okay. And you say Quez. Is that what you knew him as?
Yes.
Okay. Ay, ay, ay. Thank you. Couldn't do it without you. And is it a fair and accurate depiction of Mr. Arbery?
Yes.
Okay. At this time, we would tender States 1. Thank you.
Objection.
Okay.
No objection.
Submitted.
Permission to publish, Judge? Okay. All right. So, Ms. Flowers, that's who you knew as your next door neighbor?
Yes.
Okay. Now, do you remember the day that he died?
Yes.
Okay. All right. That is all I have for you, Ms. Flowers. The defense attorneys might have some questions for you, okay?
Okay.
I do have brief questions, but I think we need to recess, Your Honor.
Ladies and gentlemen, if we could just take a moment, if we take a 5-minute recess.
It's all right for the jury.
All right, I took a recess because, that's okay. All right, I'm just taking a recess. There was a little bit of commotion in the back. I wanted it to calm down a little bit before we started with any cross-examination.
Your Honor, for the record, I would note that the Reverend Jesse Jackson's mask is down below his nose, which I'm not a big believer in masks, but we, again, make that part of the record. And I'm sure the court can see what I'm talking about.
All right, it appears we have order back in the court. Let's get the panel.
Your Honor, may we approach?
The jury's not, I'll ask the witness to step down. Ma'am, if you can go ahead and take a step into the hallway for just a moment. Okay, the witness is not present. Ms. Hood.
Your Honor, is there a way we can do this at the bench, or?
No, we're making a public record of this. I adjourned because when the state was done, I heard some weeping in the back, and was looking at the defense to move forward, and there seemed to be an indication that we should take a pause, so I decided to take a pause. That is all. I have order back in the courtroom now, so I intend to move forward.
And Your Honor, for purposes of the record, I will have to note that I observed a number of jurors looking back. And that's why this is so difficult, Your Honor. We are advocates for our clients, but we are also human beings and parents. And there is no disrespect intended in these remarks, but my one and only purpose is to assure a fair murder trial for Mr. McMichael. And when jurors hear the weeping with a piece of evidence that is absolutely irrelevant and has nothing to do with the decisions this jury must make, but the law of Georgia allows it to come in, and then left with having jurors hear and see and visualize the emotion, and now to be comforted by someone for whom respect abounds. We're in a very difficult position now with this jury to have seen and heard and felt that. When they go back to deliberate this case and to think about the decisions that do matter in this case, and as beautiful of an in-life photo as that is, it bears no relevance to any issue in this case. So while I appreciate the court taking a break and noting your having heard the crying up at the bench, I have to place on the record that not only did I hear it as well, I saw jurors looking back at what was going on in the gallery and then looking at me. So I'm asking the court to place that on the record. Mr. Goff and I may not agree on a number of things, but the idea that this may not be the best way to handle this sort of case has become now the issue that you asked him to bring to your attention, and that is, has there been any disturbance caused by that presence?
If I could just add, Your Honor was very aware of the issue of emotion in the courtroom and how it plays out in front of the jury. And I think went on the public record and warned the gallery not to engage in that kind of behavior, and I think instructed all of us to make our witnesses aware of any evidence that might come in that would cause that kind of emotional outburst. And did so with the goal in mind of keeping this trial about the evidence. It's becoming less and less about evidence and more about emotion with these kinds of outbursts and those kinds of photographs, which, again, to echo Ms. Hogue, have nothing to do with the issues in this case. A photograph that's 8 years old and bears no real resemblance to the person we saw in February of 2020. So I would join Ms. Hogue's difficult position. I think we're all in that same position on this side of the courtroom.
And they can state. No, Your Honor. All right. So let me tell you what we're doing. I heard at the bench, some weeping, not outward crying, not yelling, nothing along those lines. So the jury was asked to leave, and this was intended to, and I think is a good reminder to the gallery that there shouldn't be any outbursts, no matter what the evidence is, whether it's this photograph or anything else. But I will point out, with what's now beginning to happen here, I do not understand, Mr. Goff, why this motion keeps being made. It is a concern to the court because on the flip side, I've seen a news report where other counsel are indicating that everybody is welcome, come one, come all. We've got a little bit of, there's an odd thing going on here that I'm watching to make sure that I've got a clear understanding of as we move forward in this trial. And I've already put my rulings on the record with regard to public access in this courtroom. That has now somehow got conflated with a photograph that was not objected to as it came into evidence. I understand the defense.
It was objected to previously, Your Honor.
That particular photograph. Yes. Okay, and that's fair enough. And I misspoke there. And I misspoke. But the point being that there's other evidence that comes in, elicits responses. I've got issues that are starting to get conflated, and we'll watch what's going on. The court's rulings, again, on public access haven't changed. The evidence is being admitted. It is an emotional trial. That is not unique when it comes to murder trials, which is why the court prefaces a lot of murder trials with, I don't want any outbursts from the gallery. So again, to the gallery, I don't want any outbursts from the gallery. This is not the place for it. We're trying to get a fair trial for the defendants and ensure that the evidence gets presented in such a way where counsel have the opportunity at some point, hopefully in the near future, to make an argument to the panel about what the evidence actually says happened on the day or days involved here. That's what we're doing. And I don't have anything else to say about it, Mr. Goff.
I might suggest that the court consider some Supreme Court precedent.
On access to the courtroom?
Maxwell v. Shepard, Stella v. Texas, and I don't remember the other name of the party, but Muzzle and Justice Souter's concurrence.
Well, why don't you tell me what your understanding of it is, and then I'll go ahead and take a look at it, or give me the full cite if you're going to ask this court to do something in the form of a motion. If you're not moving the court to do something, I'm not terribly interested in continuing this conversation.
Your Honor, I will file a written motion as soon as I can finish it. You might well imagine that we're talking about issues that we don't ordinarily encounter, even in a criminal case.
Well, don't throw up a trial balloon without some support at this point. If you think that those cases in this context move the court to do something, cite them, let me know what it is, and we'll move on from there. Because I've heard a lot of discussion here, and this is the first you're now citing case law on this. So, if you want to file something, go ahead and file it.
Thank you, Your Honor.
Thank you. Is the state ready with this? I'm sorry, it's not even ready. Let's get the witness back up. State passed the witness, yeah. And let me back it up. If you're moving for a mistrial, you need to move for a mistrial.
I move for a mistrial.
Based on?
Based on the presence of people in the courtroom and the public gallery.
Your Honor, I have to stop for one moment. We have a witness now on the stand.
If you go ahead and step down, thank you.
Thank you.
And I do actually very much appreciate the court helping me maintain a record on this. We formally moved for a mistrial under the 5th, 6th, and 14th Amendments of the U.S. Constitution, parallel provisions of the Constitution of the state of Georgia. We contend that the atmosphere of the trial, both inside and outside the courtroom, at this point has deprived Mr. Bryan of his right to a fair trial. I understand that co-counsel vehemently disagree on some aspects of that motion, and if they don't want to join, that's their business. But I represent Mr. Bryan, and my concern, Your Honor, notwithstanding what in my observation would be extraordinary efforts on the part of the court to avoid anything that would interfere with the right of these defendants to a fair trial. At the same time, in extraordinary cases like this, additional steps have to be taken. We have not secured the front of this courthouse. The Transformative Justice Coalition still flies their banner virtually every day outside in what should be protected grounds. Your Honor, we have had numerous instances several instances during jury selection of nonverbal communications between the victim's family and jurors or from juror to the victim's family. We've had several emotional outbursts during the trial of this case, notwithstanding the substantial efforts of the court to ensure that they don't take place. And we have had civil rights icons sitting in here in what the civil rights community contends is a quote-unquote test case for civil rights in the United States, eyeballing these jurors, including one today with his mask down, which the court doesn't want to make part of the record, under Supreme... I
You just
rephrased
took that a
that,
little
didn't
too
make
far.
part of the record.
Thank you.
Yeah, I rephrased.
You made it part of the record.
Well, until the court acknowledges it, it's not part of the record.
Keep going, Mr. Coffey.
Your Honor, the case law out there in mob cases and other cases demonstrates all the ways that presence in a gallery can influence jurors in a case. And I certainly don't mean to suggest that Al Sharpton or Jesse Jackson or any other pastor belong to a mob, but at the same time, we are talking about organized behavior by whoever outside the courthouse leading up to this case, where we have all these community leaders fearful that the city's going to burn down. This isn't a mob case. If you testify against a gangster, they might burn your house down. They might burn your business down. They're not going to burn your whole city down. And that is the concern that I believe jurors have expressed during the voir dire process, in that a county commissioner, a mayor, school board member, a bunch of pastors in this community, both black and white, have been talking about. So in that context, we believe the totality of the circumstances, which is what this court looks at under Shepard v. Maxwell, under the totality of circumstances, this trial has been sufficiently infected, notwithstanding the best efforts of the court, to the point where Mr. Brown's ability to receive a fair trial has become an open question. We think that line's been crossed. The court may see it differently, but we've made that for purposes of the record.
On behalf of Travis McMichael, we're constrained to join. I did notice jurors, a few, noticed the outburst. I don't think it gets any more difficult at moments like this for the family members to have to sit through the evidence. This moment feels unique in that the one piece of evidence that the state put up was not, so inflammatory, but there were several jurors that did look over. Their faces changed, the emotion, the sympathy that they felt. And to see then Mr. Reverend Jackson, whose autographed picture hung in my mother's law office for 2 decades, who is the ultimate figure of fairness and justice and equality. To see that, I don't think it gets any higher in terms of the impression that that makes. And for those reasons, I think that makes this very unique. And that's why we're constrained to join, Your Honor. Thank you.
Likewise, on behalf of Greg McMichael, we are constrained to join this motion, but for some slightly different reasons I'd like to highlight. It was apparent from the beginning of voir dire that it was going to be difficult, even long before voir dire, that it was going to be difficult to get a jury who had informed opinions, and we worked very hard to do that. And we would have loved to have had a jury that represents the demographic composition of Glenn County, which would have been 3 or 4 African Americans on the jury. We were not able to do that. I think some comments by the court in denying the state's reverse Batson motion, I take exception to them, and with all due respect, but it's continued the difficulty we've had from the beginning in trying to determine, is this the right venue for this case? We hoped it would be. We wanted it to be. But in light of what's going on now and what has been the history of this case up to now, we are constrained to join the motion for mistrial, but for these slightly different reasons.
Your Honor, let me be clear. I don't know what this talk about change of venue is. There's nothing wrong with this venue. We're not concerned about the venue, but we are concerned about the details as to how this trial has progressed, notwithstanding the extraordinary efforts that this court has made. And I certainly don't want the court to think for a moment that Mr. Brown and I don't very much appreciate the incredible amount of work the court has put into this and the thoughtfulness. But if the court's not going to grant a mistrial, I would humbly urge the court to consider adopting other precautions to ensure that the court doesn't wind up where the court has to grant that motion.
Anything from the state?
Yes, Judge. A mistrial is a proper remedy for incurable fundamental unfairness in the proceedings. There's a case from 1999, Casey, C-A-S-E-Y versus the state, 237 Georgia App 461, where jurors briefly saw the defendant in handcuffs, and that did not require a mistrial because there was no showing of actual prejudice. Quickly looking today, right now on Lexis, what we have is also Bird versus the state, B-Y-R-D. This is a Supreme Court of Georgia case from 1992. It's 262 Georgia 426. Basically holding that because the trial court took prompt, thorough, and curative action, the outburst of the victim's relative did not deny a defendant a fair and impartial trial, and his motion for mistrial was properly denied. This court obviously took prompt, thorough, and curative action by having the jury leave immediately. In addition, don't want to cite something before I actually read it, so I'm going to take a look at it. We have Simmons versus the state, 308 Georgia 327, a March 13th, 2020 case. Simmons contended that the trial court abused its discretion when it denied his motion for mistrial in response to, and they put these in quotes, emotional outbursts of the victim's family members and friends. However, the Georgia Supreme Court saw no abuse of discretion. They then cited two numerous cases there, stating that trial courts are vested with great discretion to grant or deny mistrials because they are in the best possible position to determine whether one is actually warranted or not. Measures to be taken as a result of demonstrations and outbursts which occur during the course of a trial are matters within the trial court's discretion. And of course, such discretion will not be disturbed upon appeal unless there's a showing that a mistrial is essential to the preservation of the right to a fair trial. This was minor weeping in the back, and the court took immediate curative action. Additional action can be taken to instruct the jury there to ignore any sort of emotional outbursts that take place. And at this time, Judge, we ask that you deny any sort of mistrial based on the outburst, or, well, it really wasn't an outburst. It was, in the state's position, it was kind of a gulp and a weep, like that. And that was basically all it was that the state heard. So I just want to make sure that characterization, it wasn't somebody shouting, it wasn't somebody, as they say, falling out hysterical, nothing along those lines at all. So we ask that you deny any motion for mistrial on that basis. And ask that the court take kind of into consideration the, and disregard the, how am I trying to say, the mixing up or confluence of multiple arguments about Reverend Jackson being here and that somehow having something to do with the outburst or something like this. These are all very, very separate issues, neither which independently or even together at the same time require manifest necessity for a mistrial. We ask that you deny that mistrial.
And I believe that the last word.
Yes.
Law v. Shepherd, the court's looking at the totality of circumstances here. And under the totality of circumstances, we believe that a mistrial is warranted. I think the state has certainly accurately summarize the relevant law with respect to the court's discretion and with respect to whether an appeals court would reverse a determination by this court. But still, ultimately, it is Your Honor who makes that call. And that's why you get paid the big bucks, because you're the one sitting here as the umpire in the case, the advocates. We all see things from our perspective. You're the neutral here, and you make the call. But I would just submit, under the totality of circumstances in this case, from the commencement of jury selection to today, that these defendants can no longer get a fair trial.
It appears, Your Honor, there's some language in these cases about what is now incumbent upon the court. Until the state has to hold the trembling hand of the accused, I would suggest that these types of moments don't impact the state. They favor the state. And it is now incumbent upon the court to decide to grant mistrial or to present curative instruction.
I've asked for curative instruction as an alternative at this point.
Yeah. Well, the idea that you have to then potentially inquire of jurors and ask them if they heard it and if they noticed it, we're not asking for that. However, we're at 2 strikes. We've had one outburst that's been addressed. Now we've had a second. The court has to decide what to do.
All right, anything final, Mr. Hoder?
No further comment.
All right, it's in this court's discretion with regard to any outburst in the courtroom, taken into consideration, as well as the defendant's motion for a mistrial. So I cited a couple cases. Let's see, Forney, I think it's Forney versus State, 255 Georgia 316, which actually recognizes that emotions are neither unreasonable nor unexpected during a murder trial. And the demonstrations and outbursts which occur during the course of the trial are matters within the court's discretion to evaluate. The court heard exactly what I described on the record, decided to remove the jury briefly, and it was ready to get started. Based on that outburst, the court is not granting a mistrial. As to the totality of the circumstances argument, which I think is the second argument that was presented by Mr. Goff, that gets back to what I'm starting to watch very carefully as far as what's going on in this courtroom with the jury, as well as the arguments that are being made by counsel. I'll point out that a number of times during jury selection, it was raised that jurors were being influenced by individuals outside the court. And I think it was either 4 or 5 jurors were asked specifically whether or not they were influenced in some way by what was going on outside the courtroom. And they were not. There was no, actually, if I remember correctly, they didn't even recognize or see what was going on outside the courtroom. And as counsel are aware, because I have briefed counsel, there are steps being taken by the court during the jury trial to ensure that jurors are not influenced by anything happening around the courthouse. So then we start getting into what we have now with individual members or individuals coming into the courtroom. I will say that is directly in response, Mr. Goff, to statements you made, which I find reprehensible. The Colonel Sanders statement you made last week, I would suggest may be something that has influenced what is going on here. In response to that, and to his credit, Mr. Sheffield made some comments, but did say, come one, come all. And so now the court is faced with balancing a lot of things going on outside this courtroom and doing it in a way that respects members of the public's right to be in the courtroom, as well as what I'm trying to put out there is a fair trial, right? So you need to understand, everybody, that your words in this courtroom have an impact on a lot of what's going on. And so my measured response at this point is to balance all of that out and try to move forward with the trial. I'm not granting a mistrial at this point based on these arguments that are being made, because I think, well, I'm not granting a mistrial at this point based on the arguments that have been made. Are we ready with the witness from the state? Be Mr. Sheffield. All right, let's go ahead and get the panel.
All rise for the jury. Please proceed.
All right, welcome back, ladies and gentlemen. We are ready to get back to the evidence in the case. Mr. Sheffield.
Yes. Good morning, Ms. Flowers.
Good morning.
I'm Jason Sheffield. We have not met before, right?
No.
Okay. I know that you have had an opportunity to talk with a couple of people investigating this case, and they interviewed you, and I think that's how we learned that you were the neighbor to Mr. Arbery. Is that right?
Yes.
Okay. And I think you were shown a picture of Mr. Arbery from around the time of 2012, 2013.
Yes. Yes.
Okay. All right.
We're unable to hear.
If you would just speak up just a little
I'd
bit.
say, if maybe just that microphone, it's very, needs to be pointed right at you. Or if you try to speak into it.
I'm not sure when the picture was taken.
Oh, okay. All right. I want to show you a couple of the pictures. I've shown these already to opposing counsel. I've marked them as defendants exhibit Travis McMichael 12 and 13 for identification purposes. May I approach Ms. Flowers? Thank you. Ms. Flowers, I'm going to hand these to you and just ask you if you recognize the person in these images. Would you take them from me? Do you recognize the person in Travis McMichael's exhibits 12 and 13?
Yes.
And who do you recognize that to be?
Quiz.
And are those fair and accurate depictions of him? Do those fairly and accurately show who he is?
Yes.
Okay. I move defendants exhibit 12 and 13 into evidence.
No objection.
Okay.
Okay.
All right.
Very good.
Permission to publish?
Yes.
Okay. I'm just going to show you defendants exhibit 12. And I'll show defendants exhibit 13. I don't have anything further. Thank you.
Anything from the additional defendants?
No, Your Honor.
No, I'm sorry. Oh, I didn't read your-
Nothing from the stage.
All right, thank you, ma'am. You may step down.
Thank you, ma'am.
From the state?
State calls Ann Kisler-Rao.
Swear to tell the truth, the whole truth, and nothing but the truth.
Yes, I do.
Go ahead and see.
Good morning, ma'am. How are you doing today?
Good morning. Fine, thanks.
Will you go ahead and state and spell your name for the record, please?
My name is Ann Kisler-Rao, ANNEKISLER-RAO.
And ma'am, what do you do for a living?
I'm employed with the Georgia Bureau of Investigation, Division of Forensic Sciences, also known as the State Crime Lab, and I'm employed in the Trace Evidence Section.
Okay. And what is the trace evidence section of the GBI?
With the Trace Evidence Section, we analyze small, often microscopic pieces of evidence, such as hairs, fibers, paint, glass, fractured materials, and general unknowns.
Okay. And your specific occupation, is there a term for your job?
I am a microanalyst.
And tell the jurors a little bit about your training and your education in trace evidence and microanalysis.
I have a bachelor's degree in biology from the University of Pennsylvania. I have a master's degree in forensic science from John Jay College. While I was there, I completed an internship with the New York City Police Department Crime Lab. I have been employed with the GBI Crime Lab for over 15 years, and I've completed extensive training programs in all of the areas that I perform examinations in. And I'm also certified by the American Board of Criminalistics in hair and fiber analysis.
And does your certification require you to keep up to date on the current subject matter within your area of expertise, take any sort of continuing learning, education hours, or anything of that sort?
That's correct. We have to have certain things like continuing education to fulfill points over the certification period.
And how long have you been a microanalyst?
For over 15 years.
During the course of those 15 years, have you continued to keep up your certification and your hours and your continuing education?
Yes, I have.
This might be a tough question, but do you happen to know or have a rough estimate about the number of cases you've done analysis on in your time in the GBI?
Probably over 1,000 cases.
And during the course of your employment with the GBI, have you come to court to testify at maybe hearings or trials, that sort of thing?
Yes, I have.
And have you ever been tendered as an expert before in the court from the state of Georgia?
I have.
You know roughly how many times?
Over 50 times.
Judge, at this time, the state tenders Ms. Kisler-Rao as an expert in trace evidence and microanalysis.
No objection.
No objection.
No objection. She's admitted.
Thank you, Your Honor. Were you asked to perform some sort of analysis for the case involving Ahmaud Arbery?
I was.
Okay. How many different analyses did you have to do for this case?
There were 2 analyses that were requested.
Okay. Let's start with the first one. What was the first one you were asked to do?
The first one was a fiber analysis.
Okay. And can you give the jurors a condensed or a simplified version of what fiber analysis is?
Fiber analysis is typically going to be, we will compare question fibers, which are fibers that are collected off of an item of interest where we don't know what their source is, and we'll compare those to a known source such as an article of clothing, and determine whether or not those question fibers are consistent with the known source.
Okay. When you're comparing fibers, do the types of fibers matter when it comes to comparison?
Yes, we can compare any type of fiber.
Can you explain to the jurors a little bit more about maybe the difference between natural and synthetic fibers, and maybe the ease with which those types of fibers are able to be compared?
Yes, so when we perform a comparison, we go through a number of different steps in our comparison. The first step is using a stereo microscope, which is a low-powered microscope. We use that to examine the general features of the fibers. So this can be done with both synthetic and natural fibers. The next step is the comparison microscope, which is a higher-powered microscope. There are two microscopes that are connected together by an optical bridge where we can see the question fiber and the known fiber at the same time under the same field of view. With natural fibers, we can look at the morphology of the fiber, so you can look at the general shape of the fiber to identify it. If the fiber is colored, you can look at that with both natural and synthetic fibers. With synthetic fibers, there are going to be extra features that you can examine, such as during the manufacturing process, they might add particles called delustrant to the fiber. They can have different cross-sectional shapes to the fiber. There are many different fiber types that you can have, like nylon or polyester. So these are the first two steps of our procedure, and those would be the differences that we would look at between natural and synthetic fibers.
Now, is this a multi-step procedure besides those first two?
It is.
What else do you have to do?
The next step would be fluorescence microscopy, which is another comparison microscope where we'll shine different wavelengths of light on the fibers, and different fibers can fluoresce different colors and different intensities, like bright or dull. After that, the next step is called microspectrophotometry, or MSP for short, and this is done with dyed fibers, and it is basically an instrumental technique that you can use to analyze the color of the fibers. So fibers that appear the same color under the regular microscope might give different spectra using this technique. The next step we have is called Fourier Transform Infrared Microspectroscopy, or FTIR for short. And this is done with manufactured fibers, and it can help determine the chemical structure of the fiber, and it will help you confirm what kind of fiber you have. And we can also do a melting point analysis with fibers that melt to compare the melting features of the fiber.
Now, you put out a lot of terms for us, okay? So during these various steps, are these steps required in every analysis, or can you tell based on maybe a visual cue which steps you might have to take in each analysis?
So depending on what type of fiber you have, you would not complete all of the steps. So for example, if your fiber is not dyed, we would not necessarily be doing the MSP step to analyze the color. If the fiber is a natural fiber, we would not be doing the FTIR to analyze the structure of the fiber, because we can tell that it's natural based on microscopy alone.
And in the fiber analysis that you did for this case, were you given a potential sample of fiber to look at?
I was.
Okay. And can you tell the jurors what came into your office and where they came from, and what you did to compare the fibers that came through and then your results?
Okay. So what was submitted to me was what's called a tape lift. So it's where you take a piece of tape to collect fibers on an item, and that'll collect any fiber on the surface of the item. It was submitted by a police department. And then I also received a white t-shirt, which was submitted by our medical examiner's office. And I compared the question fibers, I took a sampling of the question fibers from the tape lift. I compared 20 of these fibers to the known fibers of the t-shirt. I found that they were consistent in microscopic properties and fluorescence. These were white cotton fibers, so I did not go on to the next step in the procedure because they were not dyed and they were a natural fiber. And I found that the question fibers were consistent with the known fibers composing the t-shirt. So I could not eliminate these fibers as coming from the t-shirt. I reached this conclusion because white cotton fibers are a common fiber type and they are prevalent and they do have limited features for comparison. However, they were consistent.
So when you say cannot be eliminated as having come from the t-shirt, does that mean that they definitively came from the t-shirt?
I cannot say that they definitively came from the t-shirt. There could be another source possessing fibers that would also be indistinguishable from these.
But they were similar in characteristics.
They were consistent in all of their microscopic properties as well as their fluorescence.
Do you know where this tape lift came from in terms of evidentiary chain of custody, that sort of thing?
I can tell you like where it originally came from, who submitted it to us? Is that
Who submitted to it and where it actually came from in terms of the crime scene, if you know, and whether it's listed in your reporting?
It was identified to us as having being taken off of a truck.
And do you know the police department that submitted it to you?
May I refer to minutes?
You can.
It was submitted by the Glenn County Police Department.
And in your job, you get submissions from all over the state, is that right?
We do.
While we're talking about fibers, are fibers transferable between different objects?
Yes, they are. Anytime any two objects come into contact with each other, there's the potential for fibers to transfer off of one item onto the other and vice versa.
Like if you have a sweatshirt on or a sweater on and you take it off, there might be some fibers on the t-shirt underneath. Is that what we're talking about?
That's correct.
Now, do these fibers, does it matter what the object is in order for a transfer to happen? Are some objects easier to get transfer onto?
So generally speaking, the items are...
Objection, relevance, and generally speaking. If she has an opinion about this particular case, we'd like to hear it.
I can narrow it down, but I mean, I think in general, she's able to explain the process of transfer, and then we can narrow it to a specific part of this case.
Again, if she's going to render opinions in this case on this evidence, that's great. We want to hear it. If she's just going to generally talk about things that are not relevant to this case, then we would object.
I understood the question. She was explaining the process. If that's the case, great. But if we're just talking about other cases generally or other experience outside of this case, it's sustained. But if it is to explain her method or opinion, why don't you just restate the question?
Sure. Do you know how easy it would be to transfer cotton-type fibers to a truck?
Object to the form of the question. If she's got an opinion to a reasonable degree of professional certainty, that's fine. But if this is anecdotal testimony from personal observations that are not peer-reviewed, we've got a problem with that.
She tested the fibers.
She tested the fibers.
It's sustained.
When fibers are transferred from a garment to another object, you have to take into account the texture of the items in question. So for example, a fuzzy sweater is going to transfer fibers a lot more easily than, say, a windbreaker jacket. So a t-shirt would be somewhere in the middle. When you're transferring onto a hard surface, there's less likely to transfer a lot of fibers onto a smooth hard surface like a car than it would be onto like a more textured surface.
does the amount of fibers left behind on an object have any correlation to strength of, let me rephrase it.
Your Honor, I don't object to suggest we take this matter up outside the presence of the jury.
What's the objection, Mr. Goff?
Your Honor, if she has an opinion to a reasonable degree of professional certainty, I have no problem with that. But this is a fishing expedition. I object to it. I'm just looking, and I'm basing that based on the report I received in this case.
As long as
I have
she
one
needs to,
question.
she needs to present a foundation, you can testify as long as there's a foundation. Go ahead.
Are you able to determine how long an object was on another object based on the amount of fibers left? Generally, science-based.
I cannot determine with absolute certainty how long items were in contact. I can say that the longer that items are in contact, the more likely there is to be more fibers transferred.
Let's talk about the second analysis you did, okay? What was that second analysis?
I was asked to perform a general materials analysis, which is basically the identification of an unknown material.
Okay. And where did that material come from that you were asked to analyze?
It was identified as coming from the armpit of the body.
And the body of whom?
Of Ahmaud Arbery.
And what analysis did you perform and what were your results?
I performed, so I examined the material using our stereo microscope, our low powered microscope, and also a higher powered microscope. I also analyzed it using the instrumental technique I mentioned before, FTIR, to look at the structure of the material. And I found that it was characteristic of botanical material. So this is plant material. It can be things like wood or bark or leaves, pine straw, that type of material.
And where did you receive this material from again?
This material was received from our medical examiner's office.
And once you're done with your analysis of any case that you get in, okay, once you're done, does it go through a secondary process to determine whether or not you believe that, you know, it was accurate and that sort of thing?
Yes, every case it goes through a peer review process, so a second examiner will look at all of our notes and data and our report and make sure everything supports the findings.
And was that done in this case?
It was.
And do you believe that you followed all your standard protocols and procedures when it came to both of these analyses?
I did.
And once you're done doing the analysis, do you document your findings in some sort of report or notes?
Yes, I have notes for the case file that we retain in our computer system, and then I will issue a report on the matter.
And did you do that in this case?
I did.
Okay. And for the purposes of the record, what is your case number for both of your reports?
The case number is 2020-6001183.
Just one moment. Ms. Kisler-Rao, do you happen to know where that botanical matter came from?
It was identified to us as having come from the...
You said the armpit, was that?
The left armpit area.
Okay. But before that, you don't know where it came from?
No, I do not.
Judge, at this time, the state will pass the witness subject to redirect.
No, Your Honor.
No, Your Honor.
Yes, Your Honor. Good afternoon, young lady.
Good afternoon.
My name's Kevin Goff. I represent Mr. Bryan. I have just a few questions for you.
Okay.
A moment ago, did I hear you tell the jury that, excuse me, that you can't say definitely that the cotton fibers came from the shirt attributed to Mr. Arbery?
That's correct.
Okay. But your report doesn't say, that's not the words in your report, are they?
I reported out that I could not eliminate these fibers as having come from the shirt.
Okay. Well, would you not agree there's a huge chasm between the words in your report about you can't eliminate the possibility that the fibers came from the shirt to today when you say that you can't say definitively that they did come from the shirt? Those are conclusions in two completely opposite directions, aren't they?
Well, no, so I can't eliminate those as having come from the shirt. That is also true that I can't say they absolutely did come from the shirt. Those are not exclusionary of each other.
Logically, they're not, but they certainly convey different ideas, don't they?
I hope that I have conveyed properly the idea that I cannot eliminate these.
And of course, you examined fibers that were identified as having come from the driver's side of truck, correct?
Yes, that is what they were identified to us.
You were
as.
not asked to examine or compare any fibers recovered from either the front or the back of that truck.
To my knowledge, no other fibers were recovered.
Okay. Now, sheet metal is a smoother surface.
That's correct.
I believe that's what you were referring to earlier.
Yes.
What about grills? Are they all smooth?
They have a smooth surface. Potentially things could get caught in areas of a grill.
Hood ornaments, also not smooth.
They do have some sharper edges.
Bumpers have sharper edges.
Again, depending on the area.
Back bumpers have sharper edges.
They can.
Okay. So in the end, I think, correct me if I'm wrong, what you've told the jury, essentially, stripped of everything else, is that these fibers may or may not have come from Mr. Arbery's shirt.
They are consistent in all their properties. They could have come from this shirt, but they also could have come from another source possessing fibers of the same characteristics.
All right. Thank you, ma'am. No further questions.
Any redirect from the state?
No, Judge.
Thank you, ma'am. You may step down. She also subject to recall?
No, Judge, we're okay on that.
All right. You are released. Thank you, ma'am.
I thought we were keeping all the witnesses subject to recall.
If you want her, we can keep her, but
We'll keep her subject to recall.
Oh, she just walked out the room. We'll make sure someone gets her the message.
we know where she works, Judge.
Figure we can find her. Okay. Ladies and gentlemen, we're a good place to break for lunch. We're going to take a 1-hour recess. Enjoy your lunch. We'll see you back here right about 1 o'clock for a continuation of the evidence in this case.
All rise for the jury. Please be seated.
All right. Anything from the state before recess?
No, Judge, nothing from the state.
From Travis McMichael?
No, Your Honor.
From Greg McMichael?
No, Your Honor.
From Mr. Bryan?
No, Your Honor.
We're in recess until 1 o'clock.
Please stay.
I'm sorry.
So I'm going to hang in the corner if that's okay.
Okay, that's the state's board?
Yes, Your Honor, if that's all right.
There's no, I'll wait and see, I guess. The discussion we had on the record earlier, it occurred to me, since we're into GBI witnesses, forensics side, or crime lab side, I guess I should say, where are we timing-wise with the medical examiner?
Medical examiner is going to probably be our last witness today, and our people are aware of that. Our people are also aware of Agent Kelly, who will also be testifying today, and there's some video presentation, so.
Okay. Well,
yeah.
just want to make sure from the timing standpoint, I understand where we are. And that anybody that, because I think you've got some maybe victim witness people here, is that correct?
Yes.
Okay, and that's when you're talking about they spoke? Okay, I understand. All right, state ready then?
Yes, Your Honor.
All right, Travis McMichael? Ready. Greg McMichael?
Ready, Your Honor.
And Mr. Brown?
I think we're ready. So are we going to try and do motions for directed verdict today? We think we're going to get there?
No, I don't anticipate getting.
I was just asking about the medical examiner testimony, not the last witness. I didn't ask you who the last witness was. I don't know who the last witness would be. I just want to make sure, based on our conversation about the reaction from the gallery, I knew when the medical examiner was going to be. It sounds like the state's maybe gotten ahead of me on that, so that's been resolved.
I assume the medical examiner was the last witness. You know, we all know about assumptions. Thank you, Your Honor.
All right, let's go get the panel.
All rise for the jury. Please be seated.
All right, welcome back, ladies and gentlemen. Hopefully you had a good lunch. We are ready to proceed with the evidence in the case. State ready with its next witness.
Yes, Your Honor. The state calls Jesse Worley. Jesse Worley. Yes. And then we can put it back. Makes sense.
What's that?
Swear to tell the truth, whole truth, and nothing but the truth.
I do.
Go ahead and sit.
Good afternoon. Good afternoon. Can you please go ahead and introduce yourself to the jurors, tell them your name, and spell it for the court reporter?
My name is Jesse Worley. It's Jesseworley.
Okay, and Ms. Worley, how are you currently employed?
I work in the Division of Forensic Sciences for the Georgia Bureau of Investigation. It's also referred to as the Crime Lab. I work in the Impressions Evidence section as a latent print examiner.
Okay, and what are your job duties currently?
Primarily, my job as a latent print examiner is to analyze items of evidence that are submitted for latent print services for comparison, database searching, or chemical processing in our laboratory. I conduct database searches, I do comparisons of latent prints to known exemplars or known prints, and then issue results of reports of my results, and then testify in court when needed.
And how long have you been working in that capacity in your field?
I've been with the GBI for 14 years.
Okay, and please go ahead and tell us your education and training.
I have a Bachelor's of Science in Forensic and Investigative Sciences from West Virginia University. I graduated from there in 2007. I was employed by the GBI that fall in November, and I completed a training program that lasted about 2 years prior to being able to write my own reports. The training covered every aspect of casework that we do as latent print examiners and included courtroom testimony and evidence analysis and processing. I can complete 16 hours of annual outside education or continuing education every year as well since the completion of my training program.
Okay, and are you a member of any professional organizations in your field?
Yes, I am.
Can you tell us which ones?
Primarily, I am an active member of the International Association for Identification, which is a professional organization across the globe that is geared towards education and publications for forensic practitioners in identification sciences like latent prints, also question documents, DNA, and crime scene investigation. I'm also a member of the Georgia State Division of the IAI, and I also hold an office with that group as well.
Have you testified as an expert before?
Yes, I have.
Okay. What have you testified as an expert in?
Specifically in latent prints.
Okay. And has that been in Georgia?
Yes, ma'am.
About how many times?
It's getting close to 60. I think the last time I counted it was like 57, 58 times.
Okay. Your Honor, at this point we would tender Ms. Worley as an expert in latent print examination.
No objection.
No objection.
No objection.
She's admitted.
Thank you. Now, Ms. Worley, I want to go through some terms with you, and if you can just describe or explain those for me, okay?
Sure.
Okay. Are you familiar with the term friction ridge detail?
Yes.
Can you tell the jury what that is?
So friction ridge detail, as we refer to it in latent print examination, is actually the composition and features that are on the skin that make up the palms of the hands and also the soles of the feet. It's that detail and those characteristics that are replicated when your hand or finger or foot makes contact with a surface, and then that detail, that arrangement of those features is transferred onto the surface and leaves a latent print that we can subsequently develop and then hopefully compare in hopes of identifying it to a source.
So when I look at my finger, are you talking about the lines and grooves?
Yes. So
on my fingertips?
The skin on the palmar surface of the hands is referred to as friction ridge skin. It's made up of series of ridges and raised areas as opposed to like the rest of the skin on the body, which is fairly smooth. Within that ridge flow, there are different features where ridges either start and stop or they split into two, and it's those specific features and the arrangement of those features within the friction ridge skin that make up the detail that we use for comparison.
Now, what is an inked print, also known as a known print? What's that?
So inked prints, traditionally were taken using printer's ink on a white cardstock to record the detail of the fingerprints so that they can be used for comparison. In today, with all the advancements in technology, most known prints are now recorded digitally with a glass, like a glass plate and almost a scanner or camera type setup underneath. But the idea is the same. The detail of the skin is recorded clearly so that it can be used for comparison.
And can you please tell the jury what is a latent print?
So latent prints are what we are looking for primarily, like in evidence in a case, to determine who may have handled an item or come in contact with a particular surface. Latent prints are typically referred to as latent in that they're not necessarily visible right away when an object is discovered as a piece of evidence. The latent print may require a development technique like fingerprint powder or other chemical methods to make it visible. And then even at that point, as an examiner, we commonly refer to them as still being latent prints until we've identified them to a known source.
Okay. Now, what does it mean when an item is positive for latent prints?
At the GBI Crime Lab, the policy that we employ for determining whether an item is positive or negative for latent prints, we conduct a visual examination of the item, whether it's a lift card that has a powdered impression that was collected from the crime scene, or if we're getting in an item itself and we do the processing in-house, we're looking to see if after development there is any visible friction ridge detail that could be used for comparison. So sometimes if an item is we decide that it's negative, it might mean that there is no ridge detail on it at all, or it could be that there is some ridge detail, but it's so limited or so sparse or even like obliterated or distorted where it's not going to be usable because it's not clear enough for a comparison. That could also still produce a negative result. But at the point where we say we have enough detail present on the item to use it for a comparison, then we say it's positive.
And what does it mean when you say an item is suitable for comparison?
So once we have a positive result, that we've done a visual examination and there is usable friction ridge detail on this item or this lift card, the first step of our process is to analyze the amount of detail that's there, the type of detail, the clarity of it, and determine if it is in fact suitable for comparison. So we do the visual examination, it's either positive or negative. If we have the positive results, then we determine if it's suitable or not suitable for comparison, which is really just we're going kind of up a ladder in terms of how much quality and quantity of detail is present in the impression. So we have positive, and then if we say the analysis results are suitable, we have enough detail or sufficient detail to be able to compare it to a known set of prints.
And can you just let the jurors know what is the process that you use at the GBI for comparing latent prints to known prints?
So the first step, like as I've said, is the visual examination to determine if we have any latent print detail present. The next part of the methodology we refer to is the ACE-V method. It's an acronym for analysis, comparison, evaluation, and verification. So the analysis is the first part that I've described in determining from our positive results which of those impressions may be suitable for a comparison. Once an impression is determined to be suitable, then we'll move on to comparison, and that's taking the latent print and putting it side by side with a set of known prints and looking for similarity or differences between the latent print and any of the known prints that are on the records that we have for comparison. During the comparison, we're looking for similarity or differences. It just depends. Not every comparison will result in a match or an identification, so you may see more differences than you see similarities. But as we start to make the decision in our mind in what the result of that comparison is, that prompts the beginning of our evaluation phase, which is really the decision-making part of the process. In the ACE-V methodology, the way we use it at GBI, we can make an identification, which means that we've determined that the latent print and the set of known records we're comparing it to came from the same person. We can have an exclusion, which would mean that the latent print and the known prints were made by different sources or different persons. Inconclusive would be that there's just not enough detail to say definitively it either is or isn't this person. Or it can also be that we need a better set of records. Maybe the one set we were given may not have been clear enough in a specific area, so we may say that we need new records for comparison. And then lastly, we also use a conclusion that's called was not identified, or no identification was made, which is, it's kind of like it's not an identification, and we're confident that the latent print is not from a specific source, but we haven't compared it enough to say that it's definitely an exclusion. Exclusion decisions tend to, in some instances, be harder to make When you're doing a comparison as an examiner and you start to feel like you're making an identification because you're seeing and observing features in the same arrangement and you're seeing the similarity, it becomes very easy to say when you've reached an identification because you have like proof positive, this feature is this feature, this one is this one, and everything lines up and you can see it. When you have an exclusion, sometimes if, depending on the area, if you're looking for like within a large area of the palm, there's a lot of area to search, and you have to exhaust all the available features in the relevant area of the skin before you can confidently say that you have an exclusion. So sometimes exclusion decisions are harder to reach than an identification. And so what we have adopted in our policy is that I know it's not an identification, but I haven't fully excluded this particular person yet, and that we report as excuse me, we report that as an identification has not been made.
Now, I want to turn your attention to DOFS case number 2020-6001183. Okay? Who are the subjects involved under that case number?
According to the report that I have, the subjects that were listed on the evidence submission forms were listed as Gregory Johns McMichael, Travis James McMichael, and William Bryan.
Okay, and who's listed there as the victim?
The victim is listed from the evidence submission forms as Ahmaud Arbery.
Okay, so I want to turn your attention to the work that you did in this case.
Yes.
Okay, what items did you use to do your comparison in this case?
The latent prints that I was asked to examine were on evidence that was labeled as item 21 in the GBI Crime Lab information system. I itemized them to be 21A, 21B, 21C, and 21D. So those were all latent lift cards that were submitted.
Okay.
And then I was given known finger and palm print cards bearing the name Amy Eileen Elrod and William Roderick Bryan Jr.
Okay, and did you also use known prints of Ahmaud Arbery?
Yes, they appear as item 24.
Okay, all right. If I can just have Mr. Camarillo help me out with this here. Thank you.
Yeah, that's fine. Y'all can move around if you need to move around.
And Ms. Worley, are you able to see what's there, what's pictured? If you need to step down, you can. Just make sure you're speaking loud enough for the court reporter, okay?
Okay.
Okay. Are you able to see this?
Yes, I think so. Okay.
Okay, please be careful, please. Okay, so do you see what I have here, AE known prints? If you need to, you can.
Yes.
Okay, so Amy Elrod known prints, you said you received those, right?
Yes, those are marked as item 20A on my report.
And did you also utilize William Bryan's known prints?
Yes.
And also Ahmaud Arbery's known prints?
Yes.
Okay. And submitted latent lists, we talked about those, right?
Yes.
And did you say they were labeled 21A, 21B, 21C, and 21D?
Yes, ma'am.
Okay, so if we can just start, I guess, in reverse chronological order with D, 21D. What did you determine about 21D? If I can just get the cap off of my marker.
For 21D, after I did the initial visual examination for latent prints on that item, I determined that that item was negative. There was not any friction ridge detail that could be used for comparison.
Okay, so 21D negative for latent prints, right?
Yes.
Okay, going to 21C, what did you determine?
So the results of the visual examination for 21C was positive. There was friction ridge detail present, but upon analysis, I determined it to be unsuitable for comparison.
Okay, so positive for latent prints, but still
unsuitable.
Unsuitable.
Yes, ma'am.
For comparison. Okay, so that leaves us with 21A and 21B. Looking at those lifts for 21A and 21B, what, if anything, did you see in those?
So on both item 21A and 21B, my visual examination result is that these items were positive for latent prints. I also noted that they appeared to be duplicate lifts of the same latent print.
Okay, so we have essentially A and B are the same print.
Yes.
Okay.
And that's something that, from experience in the way latent prints work, you can't ever create the same impression twice. They're always going to have different shape, different amount of distortion and movement because of the pliability and the way the hand is built anatomically, that you can't ever create the same thing twice. So when we see lift cards that are the same in most aspects, it's likely that they are duplicate lifts where the impression is powdered and then a piece of tape is used to lift it and then a piece of tape is used to lift it a second time. And then both lifts were submitted.
Okay, so before we go further on A and B, I just want to double back to D. So were you able to compare anything to D?
No, it was negative.
Okay. Were you able to compare anything to C?
No, because it was determined to be not suitable or unsuitable.
Okay, so no comparisons here.
No, correct.
Okay, so back to A and B, positive for latent prints but the same.
Yes.
Did you use one over the other for comparison purposes?
Yes.
Which one did you use?
I used 21A because it appeared to be the first lift. The development was a little darker on the card. It was a little clearer than what was visible in B.
Now, go ahead and just tell the jurors your findings for 21A in the process that you used, of course.
So I completed an analysis of the latent print that was on 21A. I determined that the print appeared to be from the right palm of an individual and that there was sufficient detail present to determine it to be suitable for comparison. At that point, I began the comparison process by comparing the latent print to the palm print cards for Amy Eileen Elrod and William Roderick Bryan Jr. And my conclusion for both of those comparisons is that no identification was made.
Okay. So for Amy Elrod and William Bryan, you said no identification?
Yes, ma'am.
Okay. All right. What did you do next, if anything?
At that point, I compared the latent print from 21A, which again is that palm print, to the palm print cards that bearing the name Ahmaud Arbery, and was able to make an identification to that set of records.
Okay. So identified to Ahmaud Arbery.
Yes.
Okay. So positive ID. Okay. And did you testify that that was the right palm print?
I did, yes.
So from his right hand?
Yes.
Okay. Were you able to tell where on his right palm that print came from?
Yes.
Okay. So may I approach, Your Honor? Yes. Okay. Actually, can you step down, please, Ms. Worley? Okay. So I'm going to show you my hand and right hand. And if you can just show, and if you can come so we can just go this way.
Your Honor, please hold up a second.
Yeah. Go ahead. You do have your back to the part.
Oh, I'm sorry. I'll do this.
And if everybody could speak up because you're off mic.
Of course, Judge. Thank you. We will.
I'm just going to flip to the image that I had of the lift card.
Okay. And my hand is cold. I'm sorry.
Okay. So
Okay.
the shape of the impression that was made, or the shape that appears on the lift card, is indicative of being from the edge of the palm. So this area here, it's commonly referred to as a writer's palm because when you're writing and your hand moves across the page, it's usually that portion of the palm that rests on the paper.
Okay.
And so it was very similar to the shape of the palm print that was on the lift card, 21A, and then subsequently as well, 21B.
Okay. So 1 second before you sit. So if I'm holding this marker in my hand, are we talking about like that side that's resting here?
Yes, and then sometimes it varies whether it's very, straight up and down or if it's angled in a little bit more to get more of the center portion of the palm, but that's still typically referred to as the writer's palm when it's that outer edge of the palm.
Okay. All right. You can have a seat. Thank you so much.
We can move it. We can move it, yeah, we can move it. I think we're gonna move this.
Maybe we should just not touch anything.
So, Ms. Worley, what, if anything, in looking at the lift, what, if anything, did you observe as it relates to the presence or absence of moisture?
In this particular impression, there did appear to be some areas that looked like they might have been wet or had an additional amount of moisture than other areas within the same impression. In my training and my experience, one of the things that we are taught to look for as an examiner is what kind of differences may still be present even when an identification is made. As I testified already, you can never create the same impression twice. So even when we have an identification, the latent print is never going to look exactly like the known print. I know sometimes on TV they show them up on screens and they overlay them and ta-da, they match perfectly. But that's not really how latent print comparison works. There's always going to be inherent movement and distortion within any impression that sometimes may be recorded in known prints. Sometimes known prints are well recorded and they're free from as much distortion as possible. But one of the things that we have to evaluate in making an identification decision is, are we seeing differences that are due to moisture or surface or development issues, or are we seeing differences that are inherent to them being from different sources? And we have to use tolerance where appropriate in making that decision. In this instance, there were areas of the impression that do appear to be wet. The ridges do have a different appearance, and the powder does adhere or react differently to more wet areas of the impression. And so that was one of the observations that I did make in this case, but it wasn't so significant that it overreached the tolerance that I can use in making an identification decision.
Okay, so it didn't affect your evaluation in terms of the identification to Mr. Arbery?
No, but it does make a difference in explaining why, if it were to be put up for anyone to see, the latent print does not look exactly like the known prints. And one of the reasons for that is there is moisture present.
Okay, and in doing your comparison, did you follow valid scientific procedure and methods
Yes.
accepted in your field?
Yes, I did.
Okay, and are those methods reliable?
Yes. I believe actually in going through the ACE-V method, I left off the V portion. The last part of ACE-V is the verification. Our policy at GBI requires that if all of our decisions are verified by a second examiner, with the exception of the no identification decision and some of our inconclusives, but my suitability decisions for A, B, and C, those were all verified by a second examiner, and then my identification decision for item 21A was also verified by a second examiner.
Okay. One moment, Your Honor. At this time, that is all I have for you, Ms. Worley. The defense may have some questions for you, okay?
I may, Your Honor, just briefly. Ms. Worley.
Yes.
Hi, I'm Jason Sheffield. We haven't talked about this case, have we?
No.
Okay. Were you given any photographs to come along with items 21A, B, C, and D?
No.
Or is it true that you're not sure where that latent palm print came from on the item, other than it came from a truck, but you're not sure where on the truck it came from?
That's correct.
Okay.
We describe our evidence based on what's labeled on the lift card specifically.
Right.
In this case, they were simply labeled as being from William Bryan's truck.
Got it. And then 21C, which had some detail on it, Was that a fingerprint?
I believe it was, yes.
Okay, do you know from which finger it came from?
No.
Okay, and then 21D, is that simply you don't know what in the world that was, or that it was a fingerprint with no detail that could be used for comparison purposes?
Based on the image that I have available and from what I recall in working this case, there wasn't enough detail to say otherwise, and that's primarily why the result is also negative.
Right.
There's just very little detail present, if any.
So do you have the photograph of it, the card photograph?
I have a copy.
Yeah, can I take a look at it real quick?
It's not a great copy.
May I approach you? Yes. Just take a quick look to see what you're seeing.
You
I may
want
have a question, I'm not sure that I will.
the lift cards, you said?
Yeah, the one that goes to C.
C?
Yes, please. Okay, so in looking at this, do you see any detail in it that makes you believe that it probably came from a finger?
The shape of the impression and the direction of the ridge flow is indicative of it being from a finger,
Okay.
but it's still not sufficient to compare it to any known source.
So you've got some detail that you think this probably came from a finger, but then you're looking for enough detail where you can say, now I can start counting up enough of the detail to try to match it to a known. Is that fair to say?
Yes, so our determination for suitability is a combination of quantity and quality of detail. So while the number of features present is a part of the decision, it's not the total or whole component.
Okay, so D is probably a finger. We don't know which one.
D, I don't know. I
That's the
didn't
one
make
that
any
we're saying-
determination.
Okay, but it has some of the details that's consistent with a finger.
We were talking about 21C,
Oh, my
I
bad.
believe.
All right, so 21C is probably a finger.
It's very likely from a finger.
Okay, and then D is such that you can't even begin to determine whether it could have come from a finger or not?
Correct.
Okay, got it. And then you don't know where on the truck those things came from?
Correct.
Okay, very good, thank you.
No question, Your Honor.
Good question, John.
Any redirect?
No, Your Honor.
All right. Thank you. You may step down.
Thank you.
And you are excused, but subject to recall. Thank you. Is the state ready with its next witness?
Yes, Your Honor. At this time, the state's going to call Special Agent Lawrence Kelly.
Swear to tell the truth, the whole truth, and nothing but the truth.
I do.
Go ahead, have a seat.
All right, please state your name and spell it for our court reporter, please.
My name is Lawrence Kelly. That's Lawrencekelley.
And how are you currently employed?
I'm a special agent with the GBI, just the Georgia Bureau of Investigation.
All right, and what is the Georgia Bureau of Investigation?
We're a state law enforcement agency. We're the investigative arm of the state government. We, when requested to do so, can assist local agencies with investigations, or we can initiate certain investigations on our own involving certain specific violations of Georgia law.
All right, so you're a special agent. What does that mean?
It means I am a Georgia Post Council certified law enforcement officer. I have powers of arrest throughout the state. I have had specialized training in various forms of investigative practices, interviewing, interrogation, certain specialized training in examining cellular telephones and cellular telephone records and elder abuse investigations and general just investigations.
All right, so you got the normal training that the GBI provides all special agents, is that right?
Yes, ma'am.
Okay, but you have some special technical expertise.
I do.
All right, tell the jury about your special technical expertise.
I have two specialties. One is not really pertinent to this case. I'm a elder abuse or at-risk adult crime specialist. The other one, I am a technical specialist in the gathering and use of data from cellular telephones and social media records. I have specific training in to download and extract data from cellular telephones, to obtain records from various providers, and to analyze those records.
Right. So, would it be fair to say that sometimes you're the tech guy who gets called out by other fellow agents?
Yes, ma'am. Happens quite frequently.
All right. So, directing your attention specifically to May 6th of 2020, did you become involved in the homicide investigation for Mr. Ahmaud Arbery?
I did.
All right. How did that come to you?
I was called. I was not involved in the early stages. I was called by ASAC, Assistant Special Agent in Charge, Richard Dial, who was my direct supervisor, and he told me to report the next morning to assist in some technical matters involving the Arbery investigation.
All right. So he was the one who was in charge of the investigation?
He was, yes, ma'am.
All right. So Richard Dial calls you up, and at this time, did you then submit some video files to another arm of your agency?
I did. When I arrived the following morning, I submitted 2 video files that I had received from ASAC Dial that were videos, 2 videos. One was about a little over probably a minute and almost a little shy of 2 minutes long. The other one was a truncated version of that video to Matthew Heath, who is a digital forensic investigator with our Child Exploitation and Computer Crimes Unit in Decatur.
Okay, so we'll go ahead and take that piece by piece. When it comes to the Georgia Bureau of Investigation, that's a statewide agency.
We are.
So where is your office?
My office is in Kingsland, Georgia.
All right. And Matthew Heath, where is he out of?
His office is at our headquarters in Decatur, or at the time was at our headquarters in Decatur.
In Decatur, and that is close to what town?
Atlanta.
Okay. So now he was in a different unit, you said?
Yes, ma'am. The Child Exploitation and Computer Crimes Unit. GBI has 2 computer-based units, the CIAT, which is the unit I just mentioned, and the Georgia Cybercrime Center in Augusta.
Gotcha. So he is a digital forensic investigator?
Yes, ma'am. All
right, so how is his job duty different than your job duties?
He's not a sworn agent. We do some of the same things. As a cell phone expert, I can download and extract data from cell phones, and pretty much cell phones by themselves. He can do that for cell phones, computers, other devices. He also has the ability to do other technical things such as enhancing video files or reviewing video files for information.
Okay. So You sent him a 1 minute and 43-second video. Is that the video of the homicide of Ahmaud Arbery?
It is.
All right, and the shortened version of it, that was the duplicate.
Yes, ma'am. It was a truncated version originally created. I viewed the metadata. It was originally created approximately 30 some odd minutes after the first video, and it's just by truncated I mean it's just a cut portion. It's like a 36-second portion of the original full video.
All right. So did you also send him surveillance video from 219 Satilla Drive?
I did.
Did you also send him 5 surveillance videos from the interior of 220 Satilla Drive?
I did.
And were those the ones dated February 23rd of 2020?
Yes, ma'am.
Did you also send him 47 surveillance videos from 224 Satilla Drive?
Yes, ma'am.
All right. Now, with regard to the videos from 224 Satilla Drive, were 3 of them from the date in question, February 23rd, 2020?
I believe so, yes, ma'am.
All right. So the other 44, they were from January 1st of 2020.
I don't recall what date they were not from. They were from prior to the incident. I don't recall the exact date, ma'am.
Okay.
Object to leading questions, please.
Yeah, we keep them under record.
Sure. So after submitting all of this to Matthew Heath, the digital forensic investigator in Decatur, what did he provide back to you?
He provided back to me several videos that he had enhanced. One of them was a contrast enhancement. Basically, he lightened up certain shadow areas in the video. Mm-hmm. One was a stabilized video that showed portions of the video, kind of keep the video had a lot of extraneous stuff on the side, so it just showed the major part of the video. And then there were some frame-by-frame videos, still frames from each of the videos that we saw.
All right, so I'm going to go ahead and take you through this. Have you had the opportunity, of course, to review the items Matthew Heath sent back to you back in May of 2020?
Yes, ma'am.
All right. So did you have the opportunity to review State's Exhibit 191, Matthew Heath's half-speed video of the homicide?
Yes, ma'am.
All right. And was it fair and accurate?
It was.
At this time, the state would tender into evidence State's Exhibit 191.
No objection, Your Honor.
No objection.
No objection.
Admitted.
And in addition, did he also submit to you State's Exhibit 192? I think you mentioned the high contrast video of the homicide.
Yes, ma'am.
Right. At this time, the state would tender into evidence State's Exhibit 192.
No objection, Your Honor.
No objection.
No objection.
Submitted.
Publishing State's Exhibit 191. And how is this labeled? I'll back it up to the beginning. And Agent Kelly, how's this labeled?
It's 5618 half-speed.mp4.
Agent Kelly now publishing State's Exhibit 192.
How's this labeled?
5618.contrast adjustment.
Now, I'm going to stop this right here. With regard to the difference between 191 and 192, 191 was slower?
Yes, ma'am. 191 is a half speed from the original, and these are from the 36-second truncated video. These are half speed.
All right, and then the high contrast, that is at which speed?
Looks to be at full speed.
Full speed. All right. And so when we get to approximately here, which appears to be at about 10 seconds, describe this image as compared to the half-speed image. I guess, is it brighter or darker?
It's brighter. As you can see, the road on this one is kind of washed out, and the sun, instead of seeing the blue sky in the sub, you just see white where the light has washed out the pale blue in the sky.
All right, and the intent behind this is so you can see what?
See things that are might be obscured by shadow in the original video.
All right, so when we look at this right here, I'm going to focus your attention right in here, okay? Are we able to actually see what takes place here? I'm going to hit play. What happened right there?
It appeared that the person known to me as Mr. Travis McMichael raised his hands in this kind of motion.
All right. Did you see what he had in his hands at that time?
He had something in his hands. I couldn't see exactly what it was at that point. I can infer what it was from context from later, but.
And in context from later, what does he have?
A shotgun.
Your Honor, I'm going to object to the witness describing what is obviously in the video. I don't understand why the witness needs to say there are trees in the video, there's a road in the video, Travis McMichael's holding a shotgun. The video is in evidence now. The video is the evidence. The witness doesn't need to describe it.
This is a GBI investigator who received evidence, and there's a reason behind what he is doing and what he's observing as far as this case and prosecution goes, which is the details that are within these particular videos.
I guess that would be the appropriate question then. What did you do? But describing the video, it doesn't make any sense, and it's wrought with peril, Your Honor.
We are. Yeah, he's explained what he's done. You're asking him to explain what he believes he's seeing in the video? It's the same.
Okay. So, in addition, did Matthew Heath also, having received state's exhibits, or for having received the videos from 219 Satilla Drive, 220 Satilla Drive, and 224 Satilla Drive, provide you with another video?
He did. He took those videos, and basically there's extraneous material in both of them. That he cut that out to show Mr. Arbery's path through the neighborhood and through where he was seen in any of those particular videos that we submitted.
All right. And have you had the opportunity to review State's Exhibit 224?
I have.
All right. And was that what Matthew Heath had provided to you to just show Mr. Arbery's path that day?
It is.
All right. This time the state would tender into evidence State's Exhibit 221, 222, 223, and then 224, the path merged.
And if I could just have a moment, Your Honor. I'm having trouble remembering what those are.
Sure. It's going to be 221, 222,
223, and then 224, the combined.
Thank you.
Any objection?
Oh, I thought we were
No
just
objection.
clarifying. Yes, no objection. We were just clarifying the exhibits you put together.
No objection.
I think I heard the other two. Admitted.
Thank you, Judge. Looking at State's Exhibit 224. The state has completed publishing State's Exhibit 224. So, May 7th, did you also then receive from ROCIC, Caitlin Nguela in Tennessee, did she attempt to provide you what she'd attempted to do with the Greg McMichael 911 call and the Brian video as far as audio went?
Yes, ma'am. I received notice from ASAC Dial that the Glenn County Police Department had previously submitted the 911 calls and the same videos that I submitted to Mr. Heath to the Regional Organized Crime Intelligence Center, ROCIC. They also have the capability of enhancing audio and video. And I was told that some of the files were ready, and so I downloaded enhanced 911 calls and some of the enhanced video products that they produced.
All right. But the audio files, no noticeable enhancement was made?
Ma'am, with the audio files, it's not like NCIS or TV, and it really wasn't. The original video was of an audio quality that you could hear what was going on, and I don't think the enhancements brought anything new to light.
All right. But with it came to Ms. Nguela, she had also done some videos.
Yes, ma'am.
In an effort to enhance some things. Is that right?
Yes, ma'am.
All right. So State's Exhibit 129 has already been tendered into evidence, and you've had an opportunity to review that. That's the one where you said she kind of cut out some extraneous stuff?
Yes, yes.
All right. At this time, the state will go ahead and publish the 2 video files from State's Exhibit 129. I believe 129 was contained in the Court's Exhibit 3 stipulation.
Stabilized color safe levels.
I'll let you finish it.
And it's from IMG 5617, which is the longer of the two videos.
Now, publishing states, first video out of States Exhibit 129. Second video out of States Exhibit 129. What does this say at the bottom here?
Stabilized IMG 5617, which is again the longer of the two videos.
All right, publishing this. Now, directing your attention to May 8th of 2020, were you tasked with following up on tips?
Yes, ma'am. That's actually, I was actually tasked with that upon my arrival on May 7th, but with all the other things I was doing, it was myself, Agent Nicholas Anzac, and several of our analysts from the Georgia Information Sharing and Analysis Center in Atlanta, which is a GBI work unit, were tasked with reviewing the numerous tips that were coming in.
All right, so they're coming into where?
They were coming in, originally they were just coming in through either Glenn County PD or the Sheriff's Office, and then GBI announced that we had created a tip line, and most of them shifted to the GBI tip line.
All right, so you were tasked with this unit to follow up on tips that you're getting, and these are from where?
Just from the general public. I believe the video had been released publicly at that point, and people were calling in. We had asked anyone with information to call in directly about the case, but we were getting everything from...
I object to hearsay, Your Honor.
It's not being offered for the truth of the matter asserted that, I'll just make something up. Bob called in and suggested this. It goes to, they were receiving these and he took some action on one of the specific tips, which I was going to ask about.
Let's get more specific then.
I will, Judge. All right, so did you attempt to determine if Mr. Arbery could be seen running with a stick or a hammer?
I did.
All right, tell the jury what you did.
We have, as I viewed the videos, I viewed the half-speed videos. We also had all of the still-framed images that I mentioned earlier. I believe there were nearly 2,000 of them, and we picked the ones from the requisite area and reviewed them one by one.
And what were you able to determine as far as Mr. Arbery running with a stick?
Objection, Your Honor. This is not an expert opinion here. He's saying I've looked at some pictures taken from some videos that other people enhanced for me, and this is what I think I see or I don't see. This is an issue for the jury.
Join you, it's the same issues. He's looking at pictures and saying what he thinks he sees in the picture.
We join, Your Honor, and I think we're potentially opening doors to go into other tips and the narratives that they might foster.
From the state?
Wasn't going to go into any other tips or other narratives that they might foster. He was tasked with dispelling this tip or this rumor that was out there, and he went...
Characterization. Your Honor, we're now testifying, and so I think we need to take it upside the president.
No, I think I understand where we're going. Overruled. Go ahead.
Thank you.
Your Honor, were you overruling Mr. Goff's concern about going into other tips? Mine was the issue of him testifying as an expert to his review.
Actually, what I was overruled on both.
for the record.
Thank you. You may answer the question.
It doesn't appear that there's anything in Mr. Arbery's hand at any point while he's running.
Okay. All right, so you mentioned our frame by frame that Agent Heath gave to you.
Yes, ma'am.
Have you had a chance to look at State's Exhibit 314, the folder containing those?
Yes, ma'am. Yes, ma'am. The large number of still frames.
All right. At this time, the state will tender into evidence both State's 314 at this time. Just State's 314 at this time.
And I'm sorry, the witness was saying what it was, but it got, I was not close.
It is a large number. I believe there's 1,095 still images from the video.
I understand this is what he looked at as part of what he was following up on, correct?
Yes, Judge.
And as the state tendering 1,900 still images from the video, is that what you're seeking to?
Yes, we are tendering the entire 1,095 still images digitally in a digital folder.
Okay.
No objection. These are the stills from the entire video or just a selection of the video?
Okay. What I understand is being tendered in, he just testified to a review of photographs from the video. I understand these are the still photographs that were reviewed by the agent as part of his follow-up that he has already described on the record.
No objection.
No objection.
So I'm still trying to inquire, is this, if I may, while you're the witness, is this, these are stills that he did not create? These are stills that were provided to him in the pickup of the other stuff in the stipulation. Is that correct? All right, very good. But it just wasn't made very clear, so. All right, no objection from Greg and Michael.
You're admitted.
Thank you.
Sometimes our discussions are like concentric circles, and we all eventually realize we're talking about the same
I don't think
thing.
we're talking about something different.
So I'm actually going to go back. When we look at this particular folder, what does it say right down here in States 314?
The name of the first file, you mean?
No, right down here in the far bottom corner, how many are in there?
1,095.
All right. And when we open it up, are we looking at the first image?
Yes, ma'am.
And how's it labeled? At the very top.
IMG 5618 frame 00001.png, which is an image format.
All right, and how did you scroll through these?
The same way it appears you're doing it, I use the gallery function on the computer.
Such as this?
Yes, ma'am.
So I'm going to go ahead and stop here real quick for you. We're on 57,
Yes, ma'am.
and then we look at 58. Do you know why there is a difference in clarity between those two particular images?
Based on my training, since the case, at the time I didn't, based on my training since the case, it's going to probably be because there was motion blur in that particular frame, as is the camera might be moving a little bit or the car's moving. That would cause the distortion in the earlier frame.
Okay, because you're in a moving car.
Yes, the two things are moving. The car is moving, and the person taking the video is moving.
All right. Do you have any idea, I don't know if you know, do you know whether this has autofocus where it's trying to focus?
I happen to know it was taken with an Apple iPhone. It does. And anybody who's ever taken a photograph with an iPhone knows as you move it, it kind of locks in on something and tries to focus to that one thing.
Continuing to publish. If I hold it down, what does it do?
It moves forward like an animation, like a movie, one frame at a time, but it looks more like a movie.
And by the time we are here on frame 379, what's happened?
The person taking the video has moved the camera. For what reason, I can't tell, I don't know.
include all 1,095 still images from State's Exhibit 190, the actual video of the homicide.
Yes, ma'am.
Direct your attention now to State's Exhibit 315. And Agent Kelly, have you had the opportunity to look through State's Exhibit 315 prior to coming in and taking the stand today?
Yes, ma'am.
And are these just printed out stills of some of the in-focus shots from State's Exhibit 314?
Yes, ma'am. It's not inclusive. It doesn't have every shot in it, but it has the visible ones, the clear ones.
At this time, the state would tender into evidence State's Exhibit 315.
No objection.
No objection, but is this a subset of the last exhibit of printed out documents?
Correct. These are hard copy printed of select in-focus images from State's 314.
Okay, did he take some action to focus them?
No, they're just the clear ones as opposed to the fuzzy ones.
All right, but these are not images that have been manipulated to be different than the images we see on there.
These have not been manipulated in any way. They just were printed out from 314.
Yes, ma'am. Yes, ma'am. No manipulation was done.
Right, they're the good clear ones.
No objection, Your Honor. We just needed a little more foundation. Thank you.
No objection.
Clear, good.
Thank you. So, closing down State's 314. So when we look at State's 315, so for instance, just the very first one, put it up here. I'm going to zoom in a little and focus. All right, so is this just one of the still shots from State's 314?
Yes, ma'am. It's one of the from the exhibit we just looked at.
All right, so when we look at it, just so the jury's familiar, how's the state labeled that? I'll actually put it so you can see it.
It's just S for State 315, and then it's 299, which I'm assuming is the number of the frame from the previous setup.
Right. So 314. This would be still shot 299. It's only been printed out.
Yes, ma'am.
Now, you indicated you were kind of the cell phone guy. Is that right?
I am, ma'am.
All right. So go ahead and tell the jury what it is you do when you do a cell phone extraction. What is that?
A cell phone data extraction is just that. There's data maintained on cellular telephones or smart devices. It's maintained differently on either one. We use a software or a device to extract the base data from the device using various methods from the various software or equipment that we're using.
So for instance, if you have like a Samsung phone or an iPhone, do you need different computers to extract the data off those?
At the time of this, yes, ma'am. At the time of this case, we needed my agency used, or I used, we have several different methods that we use, but I was used the Cellbrite Physical Analyzer to do an iPhone, which is a software that runs off of a laptop PC. And we had a UFED, which is a device, a universal forensic extraction device, also made by Cellbrite to do Android devices, like Samsung phones.
All right, so during your investigation, were you given previous extractions?
I was. I was not given the extraction. I was given the reports of the extraction, which is when you load the extraction into Cellbrite Physical Analyzer, in order to make any sense without that software, you have to generate a report. and I was given the reports from extractions that Glenn County PD did.
All right, so Glenn County PD, were they able to give you the raw data?
They were not. I asked for it, and Detective Marcy said he did not maintain the data at that time. Since then, he has been told that it's probably best to maintain the data.
Okay, so you got the report, not the data.
Yes, ma'am.
Were you able to work with the report, though, due to the Cellbrite system?
I was. Investigator Marcy had generated the reports in what's called a UFED reader report, which can also be loaded into the physical analyzer software and reviewed.
All right, so for the purpose of your analysis on May 11th, 2020, did you look at the report, the extraction reports for Travis McMichael's cell phone?
I did.
And did you look at the extraction reports from William Bryan's cell phone?
I did.
All right. Were you able to find any communication between Bryan's cell phone and Travis McMichael's cell phone on February 23rd, 2020?
Not from that extraction, no.
All right, so I'm going to move you then forward to May 11th of 2020. Did you work with Agent Seacrest along with Mr. Bryan and his attorney, Mr. Goff?
I did.
Okay. And did Mr. Bryan consent to the download of his phone at that time on May 11th, 2020?
Yes, ma'am.
All right, so, but this, of course, is a download as the phone is on what date?
May 11th.
Okay, so this is May 11th that you're downloading this?
Yes, ma'am.
All right. And what were you able to notice as far as Greg McMichael's cell phone number and Mr. Bryan's number?
In the original extraction reports, neither McMichael appeared as a contact. In the May 11th extraction, Mr. Greg McMichael appeared as a contact in Mr. Bryan's phone.
Right. Now, also on May 11th, 2020, were you present during the entire time Mr. Bryan was being interviewed by Seacrest?
No, ma'am. I was up there for the very beginning. Mr. Bryan agreed to let us download his phone, and I took his phone in the hopes that we would be able to get it back to him at the end of the interview. The extraction ended up taking longer than we had thought it would, so we weren't able to do that.
All right. So May 11th, were you also interested in any surveillance video that Mr. Bryan may have had?
Yes, ma'am.
All right. Tell the jury what happened with regard to the night owl surveillance video.
Agent Seacrest, after the interview, came to me and said that they had surveillance at their house, and the video had caught some, might have caught some information related to the case. So I accompanied Mr. Bryan, Mr. Goff, Amy Elrod, and Agent Seacrest to the house, to 307 Burford, it's 307, the Bryan's house, to attempt to download the videos.
All right, so I'm going to show you. I'm going to go ahead and show you what's been marked as State's Exhibit 194. May I approach her?
Yes.
So, Special Agent Kelly, I'm showing you State's Exhibit 194. Are you able to recognize that document?
Yes, ma'am. It appears to be a true and correct copy of a GBI waiver of constitutional rights form.
All right, and what's that in regard to?
It's the Night Owl digital security system at the Bryan's residence.
All right, and who witnessed that?
Well, I signed it as the witness. Mr. Bryan signed giving consent.
All right, and did he sign freely and voluntarily?
He did.
All right, this time the state would tender into evidence State's Exhibit 194.
No objection.
No objection. No objection. It's admitted.
State's Exhibit 194, and this is for the Night Owl video?
Yes, ma'am.
All right, and what is the date we have here?
5/11/2020 at 18:54, which is military time for 6:54 p.m.
Okay, so once he signed the waiver and agreed to have his Night Owl surveillance system downloaded, you went out to the house. What happened?
Initially, neither Mr. Bryan nor Amy Elrod, who lived with him, could recall the password. So we began looking for the instruction manual for the device. We found that, and in the course of finding it, they were able to, and I don't remember how they remember the password. So we were able to, in the instruction manual, said that you could download a software that would allow you to view and download the videos from the device. So I did that on my GBI computer. Downloading the software and installing it was no problem, but due to a poor internet connection, downloading the videos, the download kept failing, and it was going to take an inordinate amount of time if we continued.
All right, so what did you decide to do?
At Mr. Goff's suggestion, I took the passwords, the consent form, and I had the software loaded on my computer, and I went back to where we were working out of the DNR office here in Brunswick, much better internet connection, and was able to download several videos.
All right, tell the jury what the DNR is.
DNR is the Georgia Department of Natural Resources. Their office is right there next to the Sidney Linear Bridge, that nice white building with the tower that's right there on the marsh.
All right, so you're operating out of there.
Yes, ma'am. We were operating out of a little side building out there.
And were you able to then download the Night Owl videos?
I was.
Right. Have you had the opportunity to review States Exhibit 193, the Night Owl videos?
Yes, ma'am. We actually reviewed the videos at the scene. We were able to look at them, just not download them. And then when I got back to the office, the downloads that we had didn't seem to play very well. So we actually got the DVR later and got the downloads off of them. Again, got the videos off of the DVR specifically again.
Okay, so you kind of did it twice.
Yes, ma'am, we did.
All right, but did anything change?
No, ma'am. The videos that we received, the actual ones that we could actually play, were true and correct to what I saw when I was at 307 Burford that night.
All right. So at this time, the state will tender into evidence States Exhibit 193.
No objection.
No objection.
No objection.
Admitted.
So Agent Kelly, what I'm going to do is I'm going to direct your attention first to the Night Owl video that ends in 257 within the folder labeled 194. I'm going to stop it right here. What's the jury looking at?
A video of the porch at, and I think I'm getting the address, it's the Bryan residence. I think it's 307 Burford Drive.
And what does it say down here?
Front door.
What does it say up here in the upper right-hand corner?
223-2020 at 13:09:45, which is again in layman's time is 1:09:45.
Publishing. So with this particular video system, we have about 30 seconds here. Why is that?
It appeared that the video system was motion activated, so it only records when there is motion to capture. Usually there's, as anybody's ever walked into like a bathroom with one of those motion detectors, there's a split second before it actually starts, and then if there's not a lot of motion, it turns off.
So when you looked at the Night Owl videos, you didn't have one continuous long video.
No, ma'am. There were short little snippets.
Right. Publishing then within States Exhibit 194, the video ending in 258. All right, so once again, I paused it right at the beginning. What time are we looking at up here in the upper right-hand corner?
At 13:11:04, 1:11:04.
All right, so we're talking about 2 minutes later?
Yes, ma'am.
Publishing the video with the last three numbers, 258 within States Exhibit 194. So even though we don't have anything happening here, any motion within the video, it's still taking this 30-second snippet?
Yes, ma'am. My understanding of how the motion video works is once the motion is activated, it takes video for a certain period of time. If there is continual motion, it will continue to record. If it's not, it will stop recording.
And I want to correct the record for a minute. This is State's Exhibit 193 is the folder containing the images. State's Exhibit 194 was the signed waiver. So if I misspoke earlier, this is the folder labeled 193. We're now going to look at the video with the last three digits, 261. So what is the time on this, the video ending in 261?
13:11:03 is when it starts.
Was there any video with this angle before this?
Not that I recall, no ma'am. Well, not on that date anyway.
And were you able to then find any video afterwards? Meaning, as Mr. Bryan pulls the truck up, was there another video showing what he actually did out in the street?
No, ma'am.
Now bringing your attention to the video for 278. What time do we have here?
13:58:09.
Same day?
Same day.
So 13:58 hours. When we saw the one with this truck, that was at 13:11 hours.
Yes, ma'am.
Right. And then publishing video 312. What's the time we now have here?
14:40:18.
And do you have any idea why Mr. Bryan is coming back to his residence on a bicycle at this time? All right, so let's go ahead and talk about May 13th of 2020. Were you present when Agent Seacrest had another interview with Mr. Bryan and Mr. Goff?
I was not present for the interview. After the interview, I was told that we had consent to download a Facebook page.
And did you in fact download his Facebook page?
I did.
All right. So with regard to Mr. Bryan's Facebook page, was he a member of the Satilla Shores Facebook group?
He was not.
And was he Facebook friends with Travis McMichael?
Not on May 13th, no ma'am.
And was he Facebook friends with Greg McMichael?
Not on May 13th.
All right, so when you downloaded it, you were able to see who he was friends with on that date?
Yes, ma'am. The downloads on the date that the download actually takes, but you actually download it. We use the feature, it's a feature of Facebook that just allows any user to download their page. I was provided from with the passwords and user credentials, and was able to, I believe I actually used his phone to do it, to download the page.
Okay, so this isn't like an official record from Facebook or anything?
No, ma'am, this is not, we didn't get this from Facebook.
All right. So
We didn't get it from the provider through legal methods. We got it through the consent and downloaded it, logged into his Facebook page and downloaded it just like anybody else could.
all right, so would it be fair to characterize it as a snapshot as it was in May of 2020?
I'm going to object to her testifying and leading the witness, Your Honor. She's got it on direct.
That's good. Ask him a direct question.
How would you characterize the download for May 2020?
It is how the account appeared on the day at the time that I initiated the download.
Was there any historical data?
There was historical posts and things that were just like anybody in your Facebook feed. It stays there until you delete it or until it eventually, I guess, goes away. I've gotten Facebook information back many years though, so I think you actually have to delete it for it to go away.
Okay. Is there any way for you to know, based on the download for May 13th of 2020, whether Mr. Bryan had deleted anything?
No, not with that. Not with the information from the download.
Right. May 15th, did you continue to assist with looking into tips from the GBI tip line?
I did.
All right. And were you tasked with looking into another social media website, not Facebook, but a different one?
Yes.
Which one?
Several actually, Nextdoor and Snapchat.
All right. So regarding nextdoor.com, what did you do?
I sent a preservation letter to through their legal compliance office. Preservation letter is just federal law allows law enforcement to preserve certain records of electronic communications providers, social media platforms, cellular telephone providers, things like that. And all you have to do to preserve it is send a letter with case number.
All right. So you sent a preservation request to Nextdoor?
Yes, ma'am.
Did you send a preservation request to any other provider of cell phone data?
Yes, ma'am. Verizon, AT&T, I believe we sent one. Apple, we sent one. We sent several that day.
Okay. So let me ask you this. How in dispute was it as far as the defendant's location on the day of February 23rd, 2020?
It wasn't. It's just sometimes it's nice to corroborate information that you already have with additional information.
All right. So this was out of an abundance of caution?
Yes, ma'am.
May 18th, 2020, did you also download someone else's Facebook data related to Mr. Bryan?
Yes, ma'am. Amy L. Roth, who I believe she was his fiancée at the time. They were living together.
And then May 19th, Ms. Elrod's cell phone?
Yes, ma'am. She could not provide her cell phone. Agent Seacrest told me, and I later verified that she had provided consent to do both. And I was not able to get her. She had to work, so we had to get her cell phone the following day.
All right, now I'm going to jump forward to May 19th of 2020. What was going to take place on May 19th of 2020?
I'm sorry. Do you have any idea how much longer this examination is going to be? I need a bathroom break, and I'm trying not to be disruptive.
I have 5 more questions and nothing else to publish. All right. What was going to take place on May 19th, 2020?
A search of the Michael's residence.
All right. And what did you do to assist in that execution of a search warrant?
Prior to the search, I searched the tax record of 230 Satilla Drive.
Okay. And who actually owned 230 Satilla Drive?
The Scoggs, I don't remember theirs. I believe Amy was the first name of one of them. They're from Athens, Georgia. I don't remember their exact address in Athens.
All right. So 230 Satilla Drive, owned by the Scroggs of Athens, Georgia. What did you do next?
When I accompanied the agents who did to perform the search.
Right. It would be fair to say all you did was seize the Wi-Fi router?
That's all I did. Other agents did other things, but we were interested in some of the data we had gotten off one of the cell phone dumps, had the Wi-Fi router information. We were trying to verify it was that router.
Got it. And then going ahead to June 30th of 2020, did you send a preservation request to some other agency? Or rather, Amazon.com?
I did. Intermedia, I think, which is owned by Amazon, is who I sent it to. It's for the Blink camera systems.
All right, and who had a Blink camera system?
Larry English.
Did you ever get anything back from Amazon.com or the other company with regard to the Blink camera
We
system?
never got a response that they had received the preservation request. I don't know if any. It was not my purview at this case to issue warrants. So I don't know if any warrant was obtained or anything like that. But we never got verification that they preserved the records.
All right. Now, on June 4th, did you actually get feedback from Nextdoor.com?
I did. I received a telephone call from their legal analysts and their counsel of record, and they advised that they had done a diligent search of their records based on the information that I had provided them, plus publicly available information at the time, to see if there was anything in their system that would be relevant to the case or important, and they were unable to find anything.
Were you specifically looking for Larry English's potential Nextdoor stuff?
Well, yes, we were looking for references to the case in general. We're also looking at any references to crimes in the Satilla Shores or adjacent neighborhoods.
Nothing of relevance?
Nothing of, it's what they told me, nothing of relevance was found.
All right.
And they didn't provide anything.
Gotcha. And did you eventually receive the cell phone records back from Verizon for Travis McMichael and Greg McMichael?
I did.
And at some point in time, were you given an extraction report for another person's cell phone?
I was. Special Agent Chad Lott with our Region 4 office, who is my counterpart over there, he's the cell phone person over there, had downloaded Mr. English's cell phone and provided me with actually the data. It was not a report. He provided me with the data, and I generated the report.
All right. So now, the videos of the interior or exterior of 220 Satilla Drive, when they came that way to you from Larry English's phone, did they have dates associated with them?
Yes, ma'am. Yes, ma'am, they did.
All right. And were you able to find them embedded in texts that he had sent to other people?
Yes, ma'am. Some of them were duplicated, which is indicative of them being associated or forwarded or sent out in a text message. And we also found them within the text messages, in the bodies of some of the text messages.
All right. All right, I will pass the witness.
All right, ladies and gentlemen, we're at a good time to go ahead and break. Why don't we go and take a 15-minute recess? Again, do not discuss the case amongst yourselves, and we'll see you in about 15 minutes.
All right, for the jury.
All right, Agent, you can go ahead and step down. I remind you that you're under oath. Do not discuss your testimony with anybody during the recess.
I won't, so I'll just be
Thank you. All right, we're in recess for 15 minutes.
clear.
All right, we are back on. Defendants represented by counsel. Should be ready to go. The witness has been passed. I guess we'll get the witness seated. All right. Remind you you're under oath?
Yes, sir.
All right. All right, let's go get the panel.
All rise for the jury. Please sit.
All right, well, welcome back, ladies and gentlemen. As I indicated, be ready to proceed in 15 minutes. I believe we are. Mr. Sheffield.
Yes, thank you, Your Honor. Good afternoon, Agent.
Afternoon, sir.
I'm Jason Sheffield.
It's nice to meet
We
you.
haven't spoken yet before right now, have we?
I don't believe so. I spoke to one of the defense attorneys over the phone a while back, but I haven't.
What do you mean, I don't think?
I don't believe so.
Okay, so one of the questions that I'm having you answer today is on the idea of communication between Roddy Bryan and Travis McMichael on February 23rd. And so you were asked to look at cell records, right?
Yes, sir.
Okay, and looking at the cell phone number of Travis McMichael, meaning any phone calls that he may have made from that cell phone on that day, right?
I did.
You did. And looking at Roddy Bryan's cell phone to look at any cell phone calls he may have made on that day, February 23rd, right?
Yes, sir.
So in terms of on the subject of whether Travis McMichael and Roddy Bryan were on the phone with each other at any point during the 23rd, the answer is a resounding no.
That is correct. I found no evidence of communication.
That's right. And in terms of looking to see whether Travis McMichael had a friendly Facebook connection with Roddy Bryan, or they followed each other or friended each other, you looked at their Facebook pages, correct?
I looked at Mr. Bryan's Facebook page.
Right, and on that Facebook page, you saw zero Facebook connection between he and Travis McMichael.
On May 11th, yes, sir.
On May 11th.
Yes,
You're trying to figure out all the time, but all you're limited to is May 11th.
Yeah, just from the records I had available.
All right, fair enough. You also had some communication with the medical examiner's office in this case, right?
I did.
Okay, do you recall talking with the Shannon Walden at the medical examiner's office?
I did.
Okay, and one of the things that you were tasked with was to try to work with the medical examiner who literally looked at Mr. Arbery's body and the gunshot wounds on Mr. Arbery's body, correct?
Not really. I was tasked with following up a tip of someone who had claimed to have gotten information from the medical examiner's office about the order of the shots.
Okay. And based on your inquiry back around May 7th, 2020, it was your understanding that the medical examiner did not have an opinion on the order of the shots, correct?
Right, that is correct. At that date, there was
Said
no
he
opinion.
he could not determine that.
No, that is correct.
Okay. Thank you.
Agent Kelly, you had William Roddy Bryan's phone number when you did your work in this case?
I did.
And you had the extraction of his phone that the Glenn County Police Department had done, right?
Yes.
You had Greg McMichael's phone number when you did your work in this case.
I did.
And prior to February 23rd, you saw no communication between those two phones.
That is correct.
On February 23rd, 2020, no communication between those phones.
That is correct.
Thank you, sir.
No questions?
Any redirect from the state?
No, Judge.
Thank you. You may step down. You are released for the day, but you are subject to recall.
Thank you, sir.
At this time, the state will call Brian Leopard.
So we tell the truth, whole truth, and nothing but the truth.
I do.
Go ahead and proceed.
All right, please state your name and spell it for the record.
My name is Brian Leopard, B-R-I-A-N-L-E-P-P-A-R-D.
And Mr. Leopard, how are you currently employed?
I'm employed by the Georgia Bureau of Investigation Crime Lab in Savannah. Actually, in Pooler. I'm sorry, we moved a couple years ago.
Okay. So what does the Georgia Bureau of Investigation's Crime Lab do?
So we're a forensic science agency. We analyze evidence that are submitted to us by outside agencies. Those might be police departments, the GBI investigative, the GBI investigative division, sheriff's departments, district attorneys, other medical examiners, other people that are in the law enforcement and legal community in the state.
And how long have you been with the Georgia Bureau of Investigation's Crime Lab?
About 16, a little over 16 and a half years.
All right. And what is your job title?
I'm a firearms and tool mark examiner.
Tell the jury about your job duties and responsibilities as a firearms and tool mark examiner.
Yeah, routinely I am called upon to determine whether or not a bullet or a cartridge case was fired from a specific weapon. If no weapon is submitted, to determine what type of weapon a particular bullet or cartridge case may be consistent with being fired from. I'm also perform function testing on weapons. I perform serial number restorations. I perform muzzle to target distance determination on weapons. I perform general tool mark analysis, as well as other various job duties related to firearms.
All right, so tell the jury a little bit about your training and education in the field of firearms and tool mark analysis.
Yeah, so I have a bachelor's of science degree in chemistry from Georgia Southern University. Since being employed by the GBI in 2005, I underwent an extensive training program of approximately a year and a half. That was basically a year of both academic work and training, as well as other various practical exercises. The last 6 months of that year and a half was actually working cases under another qualified examiner called supervised casework, where we work cases, and those are then looked at by a second qualified examiner. I've attended numerous firearms and ammunition manufacturing plant tours where I've seen different ammunition components as well as firearms produced, manufactured in their respective manufacturers, by their respective manufacturers. I have completed numerous armors courses on weapons function testing by different manufacturers. I've currently worked somewhere in the neighborhood of 1,500 to 2,000 actual firearms cases. I've examined somewhere between 2,000 and 3,000 weapons, performed thousands of microscopic comparisons, as well as other different things in the firearms field.
All right, so at this time, the state will tender Mr. Leopard as an expert in firearms and ballistic analysis, as well as tool mark analysis.
No objection, Your Honor.
No objection.
No objection.
He's admitted.
All right, so let's go ahead and start. Go ahead and explain to the jury what the difference is between a semi-automatic handgun and a revolver.
So you can kind of classify those two things both as handguns. A semi-automatic handgun normally has a magazine of some sort. Many times that is a box magazine that's loaded into the bottom of the weapon. A revolver has a magazine that is in the center of the weapon. That's normally is the cylinder of the weapon. The main functional difference or end result difference is that when you fire a revolver, the cartridges and the resulting cartridge cases, those are the fired spent components that hold the gunpowder. They stay in the weapon. In a semi-automatic handgun, those stay there. Sorry, for the revolver, those stay there until they're manually removed from the revolver by the shooter or by someone else. In terms of a semi-automatic pistol, that weapon is loaded by a box magazine, and it is fired. Every time it is fired, a cartridge casing, that's the fired ammunition component that holds the gunpowder we talked about, that's automatically, semi-automatic is where the name comes in, extracted, ejected from the weapon, and the next one is fired in. The next one is loaded in. That happens in a split second. So as long as you pull that trigger of that weapon, it will fire unless it runs out of ammunition or malfunctions in some way.
All right, so coming out of the end of the barrel of a gun, like a revolver, what comes out of the end besides kind of the projectile that might hit somebody or hit a wall?
And so you've got the projectile, obviously, and then you've also got both partially burnt and unburnt particles of gunpowder, also a bit of lead that comes out with that.
All right, so what's soot?
Soot's sort of a layman's term for the combination of all of those things.
And stippling?
Stippling is the mark that's made on a particular object if that object is close enough to the end of the muzzle of the gun to be hit by that, by the gunpowder.
So if something's really far away from the gunpowder doesn't hit it, you're not going to see stippling?
Correct.
All right, but if it's close enough, you might see stippling on what kind of surface on a person?
On their skin.
Would you see it on their clothing if they had clothing over the skin?
Not likely. You could see the embedded particles of gunpowder because the gunpowder, if it's relatively close to the muzzle of the gun, it will stick in the fabric itself.
Does the fabric make a difference, like what the person's wearing when they're shot?
Yes.
All right, so a leather jacket's different than a t-shirt?
Correct.
Okay. So I'm going to draw your attention to the Department of Forensic Sciences case number 2020-600-1183. Did you perform an analysis in this particular case?
Yes.
All right. So who submitted the evidence to the Georgia Bureau of Investigation's crime lab?
There was different evidence submitted by both the GBI Coastal Regional Medical Examiner in Pooler, as well as the GBI Region 14 office out of Kingsland.
All right, so you got a whole bunch of different evidence from a bunch of different places.
Correct.
All right. So I'm actually going to kind of start backwards for a second here. So I'm going to show you what has been marked as State's Exhibit 339, which has been made safe by our Sheriff's Department here, okay? So I want you, so it's been opened, but I want you to take a look at State's Exhibit 339 and see if you're able to recognize this exhibit.
Yes.
How are you able to recognize that particular item within State's Exhibit 339?
By its unique case number, which is 2020-600-1183. I believe we spoke of that already. It's submission number 19, and the item contained within is a .357 Magnum revolver, and it is serial number AA Alpha Alpha K 7222.
And was this submitted to you for analysis in regards to this particular case, the homicide of Ahmaud Arbery?
Yes.
All right. At this time, the state would tender into evidence States 339.
No objection.
No objection.
No objection.
Admitted.
So what else is in that particular item number, your item number 19, States Exhibit 339?
There's also a holster.
Did you do any sort of analysis on States Exhibit 339?
I did not.
Okay. Were you able to determine whether that particular Smith & Wesson .357 Magnum was in working order?
May I refer to my notes?
Yes, of course, if it would help with you refresh your recollection.
Yes, I was able to determine that State's Exhibit 339 was operational as I received it.
All right. So capable of firing?
Yes.
All right. And when it came to you, did it have ammunition in it?
Yes, it did. It had 6 .357 Magnum cartridges in it.
I'll go ahead and take that back. Okay. Thank you. So when evidence comes in to the Georgia Bureau of Investigation's crime lab, tell the jury how it actually kind of comes into you and how you keep track of it.
Yeah, so when evidence is submitted to us, the submitting agency fills out an online submission form where they indicate the stuff like the case number, the victim or suspect name, the evidence that they're submitting, what it actually is. They put all that stuff in, and then when they come in, they bring the submission form in with them. Those items are then placed into a secure lockbox by the submitting agency. That lockbox is only accessible by from the inside part of the lab, so it's a sort of a double-sided box. One side they put it in and they put the key inside, and it's locked at that point. No one can access it from the outside. The inside staff is the only one that has access to that, and it's locked. And once they put that evidence in there with the submission form, the evidence receiving staff in the lab takes that evidence out. They verify the information on the submission form that it matches what's on the evidence packaging, and then they take and they finish entering the rest of the case into the LIMS system. LIMS is the Laboratory Information Management System. That's the system by which our lab keeps track of all of the evidence. It's all barcoded. At that point, it's all photographed. It's given a unique case number and item number so that we can track it throughout the lab system until it's returned to the submitting agency or the court or whoever.
All right, so in this case, the Department of Forensic Sciences case number 2020-600-1183. What did you actually receive from the medical examiner within your office?
Yes, referring to my notes again, there was a number of different items, pellets, wadding, that were submitted from the GBI Coastal Medical Examiner's Office to us for analysis.
All right, so I'm going to show you what's been marked as States Exhibit 342 and 343. See if you're able to recognize this.
Yes, 340, sorry, 342, I recognize. It's the same case number I mentioned before. It's the submission number 3. States 343. It's the same case number. It's submission number 4.
All right. This time the state would tender into evidence States Exhibit 342 and 343.
No objection.
No objection.
No objection.
Admitted.
So, States Exhibit 342, what are we looking at?
342 is some pellets, arson pellets.
All right. What kind of pellets?
They are lead pellets.
You able to tell what kind of gun they came from?
Presumably they come from a shotgun. Most times lead pellets of this size would come from a shotgun. There's a few odd exceptions to that, but normally pellets like this come from a shotgun.
All right, and what is States 343?
States 343 is a combination of both pellets and wadding, similar types of materials as the other, just more in different types.
Gotcha. All right. So when it comes to these kinds of pellets, you know, we see on TV with CSI, you match up this gun to this piece of ammunition or this bullet and that kind of thing. Can you do anything with those pellets?
Not in terms of matching them, no.
Tell the jury why not.
Because normally when we look at couple different things there. We're looking at a projectile when we match, as you said, something to a particular gun to identify that it was fired from that gun. These don't make marks that are sufficient or in any way comparable, because they're just random balls going down the barrel of a gun. There is a shot cup, but those aren't normally compared to a shotgun unless there's some very extenuating circumstance where the plastic could maybe leave a random mark. Shotgun could maybe leave a random mark on the plastic of the waddings, but normally those things are not compared.
Gotcha. All right. So I'll go ahead and take that back from you. Thank you, sir. So, what then did you get from the Kingsland, Region 14 of, let me make sure I get this right. What did you get from GBI Region 14, Kingsland, via lockbox?
There were a number of different things. I was submitted the revolver we just looked at a few minutes ago. There was a 12-gauge shotgun. There were different waddings, 12-gauge cartridge cases, 12-gauge cartridges, excuse me. Those are the unfired rounds that were submitted to the crime lab by GBI Region 14.
All right, what's the difference between a cartridge case and a cartridge?
So a cartridge, specifically as it refers to a shotgun, is also sometimes called a shot shell. Cartridge is the unfired ammunition component. In terms of a shotgun, a cartridge contains the pellets or other projectile, if that's the case, waddings, and gunpowder. The gunpowder propels the wadding and the pellets downrange out the end of the barrel of the gun. At the point that it's fired, that thing is empty, and it is that point a cartridge case or a fired shot shell.
All right, so I'm going to direct you to what has already been tendered and admitted into evidence as States 332. It's been made safe by our Sheriff's Department here. Okay. Would it help you to come down here and look at it rather than up there?
Yes.
All right. If you may step down, Your Honor. Yes. All right, Mr. Leopard, take a look at States 332 and see what we've got.
just for the courtesy of the court, the weapon is unloaded. All right, so within step 332, the main item in there is a 12-gauge Remington shotgun. It is serial number C659540M.
All right, and is this the shotgun that you received in reference to this particular case, the homicide of Ahmaud Arbery?
Yes, it is.
All right, what else is in there?
There are also some test fires that were made by myself, as well as 12-gauge cartridges that were submitted with the weapon.
All right, so I'm going to have you turn so we're looking at the jury right here.
Sorry.
So that's okay. So you get the shotgun, and then you said there are test fires?
Yes, the test fires are in this package. I can open that if you like.
Sure.
These are 2 test fires I made.
Now, these particular cartridge cases,
Yes.
were they submitted as cartridges to you with that particular shotgun?
Yes, so in this package here, I can open this as well, and I can answer your question.
Good question.
In this package, there were 4. This is item 11C, the bigger item. My submission was item 11. This is item 11C. There were 4 12-gauge cartridges in here, and I used 2 of those to make these 2 test fires, and these are the 2 remaining.
All right, and why were you making test fires?
Those test fires were made as part of a muzzle-to-target distance determination that I was asked to perform.
All right, so when this shotgun first came to you, it had 4 cartridges that could be fired in that shotgun?
In this package, yes.
Okay. Did you get any empty or fired cartridge cases?
Yes.
All right, so I'm going to direct your attention over here. I'm going to show you what has been marked as State's Exhibit 334. I'm actually going to have him continue to stand, if that's okay.
He's got his back to the chair, that's
And
fine.
I'm sorry, so 334.
Yes.
I'm going to have you take a look at 335 and 336. I was just looking for scissors.
Okay.
Not sure if I have any.
States 334 is same case number we mentioned before. It is submission number 14. And it is a single 12-gauge cartridge case fired shot shell.
.335.
.335 is same case number, submission number 15. It is a plastic wadding.
Thank you, sir. And 336.
336 is same case number. It is submission number 16. And it is a single 12-gauge fired shot shell.
So with regard to, I'm going to step in front of you real quick, with regard to states 334 and 336, did you do a comparison on these fired shot shells with that shotgun?
Yes, I did.
And what were you able to determine?
May I refer to my report?
Yes, of course. Please take a stand.
I was able to determine that those two items were fired in the firearm. I don't remember state's exhibit, but it's the 12-gauge Remington shotgun we spoke of.
So the 12-gauge Remington shotgun, State's Exhibit 332, fired those two shell casings.
Correct.
Now, I believe you testified that you were asked to do a muzzle to target distance analysis.
Correct.
All right. And did you in fact do that?
I did.
All right. So what was submitted to you so that you could do this analysis?
There was some clothing from the victim.
Clothing from where? I just didn't hear.
I'm sorry, I didn't.
Where did you have the clothing came from who?
I'm sorry. The clothing was submitted by from the Coastal Regional Medical Examiner's Office.
Right. And did you also have the opportunity to review State's Exhibit 190, the video of the homicide in this case?
Yes, I did.
Did you also have the opportunity to review State's Exhibit 314, the frame-by-frame images from State's 190, the video?
I reviewed those, yes.
And did you also have the opportunity to review some crime scene photos of Mr. Arbery's body?
Yes.
And once you did that, what did you do to perform your muzzle to target distance analysis?
So I looked at the clothing that was submitted. Specifically, there was a white T-shirt that I examined. Made notes, took measurements, photographs of that shirt, and looked at specifically the entry holes in the shirt. I tested some particles chemically to determine the presence of fired ammunition or fired gunpowder chemicals, if you will. I looked at those. I also looked at, we spoke about the photos, looking at where that stuff was assimilated to the defects, the gunshot holes of entry and exit on the body. And I made my analysis based off of that.
And what was your conclusion?
My conclusion, sorry, I keep forgetting about the mic. My conclusion was that the areas on the shirt, the defects on the front of the shirt, I don't know the state's exhibit number, but that you mentioned, but it was Mr. Arbery's shirt, was microscopically examined and chemically processed for the presence of gunshot residues. The examination revealed the presence of gunshot residues and a physical characteristics consistent with contact or near contact gunshot holes of entry.
Okay, so we've got contact or near contact gunshot holes of entry. Is that right?
Yes.
Okay, so I'm going to show you what has been marked. I'm going to show you what's been marked as State's Exhibit 401 through 409. Take a look at 401 through 409 and see if you're able to recognize those particular photos.
Yes.
How are you able to recognize 401 through 409?
All of them except for 406 were photos that were taken by myself during my analysis. 406 appears to be, there's no identifying, other than the date and time stamp, and I don't have a recollection of when this occurred exactly, but that does appear to be the body of Mr. Arbery.
All right. And was that sent to you by myself so that you could review it?
It was, yes.
Okay. So at this time, the state would tender into evidence states 401 through 409.
Is 406 duplicative?
406 is duplicative of the crime scene photos. It's just the one he looked at.
Okay. No objection.
No objection.
No objection. Admitted.
All right. So let's go ahead and take a look at 401 through 409. You'll be able to see them on your screen right here. So when looking at State's Exhibit 401, what's the jury looking at here?
State's Exhibit 401 is area, what I marked as Area 1. That was at the left shoulder area of the white shirt.
Okay, so
And by shoulder armpit area.
shoulder, armpit area. So that's right here.
Yes.
Okay. And what was your determination about this particular? Was contact, near contact, or something else?
That it was contact or near contact.
And what do you mean by contact or near contact?
That the end of the shotgun was very close to that fabric when it was fired. That's evidenced by looking at the large hole there. That hole, just by looking at the ruler, I could look at my notes for a more specific measurement, but it's 4 or 5 inches across. Normally when pellets and wadding exit a shotgun, for the first few inches, foot or two, they will be in a single shot string. That shot string's give or take an inch or so in diameter. So to have something that large, it had to be made by in my opinion, made by the gas from the tearing of the large amount of gas that exits the end of the barrel of the weapon. Also observed is the rolling of the fabric where the edges of it are seared and rolled up. That's also something that's indicative of a contact or near contact shot.
Something like that? Or is that part of the fabric?
It's kind of difficult to see. I mean, in the sort of middle top there, you can see where it's rolled up. The edges there, yeah, appear to be rolled up. It's a little fuzzy on my end, but.
Are you able to say, based on just the fabric that you looked at in the photo of 406, whether this shotgun was pressed up underneath his arm, or here, or here? I mean, is it easy to say or hard to say?
Just by looking at the photo, I mean, I would say, like I said, it's contact or near contact. There's a little variation there, but it has to be pretty close for that to happen.
Okay. So then when we look at State's 403, what are we looking at there?
The State's 403 is again, those notations are by myself. Those were marked. That's the back left. So that the shirt there, as you see it in the photo, the back is folded over so that you see the back left shoulder of the shirt. Those appear to be exit. They're consistent with exit marks by pellets that had gone through the body and are starting to exit on that side.
So when we look then at State's Exhibit 402, what's the jury looking at there?
So 402 is what I call defect areas 2 and 3. That is positioned where the neckband of the shirt would be in the top of that photo. So in the uppermost chest, you would have that defect area there. which is, yes, in that area that you were pointing at. Those 2 holes, those were consistent with the top, and we'll get to it. I was presumably another photo in a minute, but those are consistent with being directly over and associated with the chest wound of Mr. Arbery.
All right, so Mr. Arbery had 1 chest wound. How do we
Yes.
have 3 holes?
I don't really know. To be able to say that, you know, that bottom hole could very well be associated with the chest wound that is directly above it. It would just be a bunched up fabric where you're making contact with, the gun is passing through, the pellets are passing through those 3 areas at the same time. That's plausible. The other would be that bottom area is a fired and missed shot that did not make impact with the chest area.
But we don't know.
I don't know, no.
And so when we look at 404 and then 405, what are we kind of looking at here with these 2 sort of
So
images here?
these are that one.
404?
Yes, 404 is diphenylamine. That's a chemical I use to look for. It's either nitrates or nitrites. I apologize. Those are from the the unfired gunpowder particles. So they have a particular shape that we look for. They're either ball shaped, flattened ball shaped, disc shaped. There's some other shapes there, but we look for those, and then sort of the chemical confirmation is that it turns out blue. So this is a positive. This just shows that the diphenylamine test solution that we're using is working. We take a piece of gunpowder that we know is gunpowder, and we test it with that.
And so what do we have in 405?
Those are some particles that, although they didn't look like gunpowder, they appear to be consistent with Grex, which is or shot buffer, which is a portion of the loading of many shot shells that make the pellets sort of have something in between them. It's sort of sidetracked here, but it's to prevent what we call billiard ball effect, so that when the pellets are fired, they don't bounce against each other and cause themselves to spread out faster. I suspect that's what that is. It didn't test positive for gunshot residues, but it was something that I wanted to make sure it was not gunpowder. Even though it didn't look that way, I tested it.
Where'd this come from?
Those were collected from the shirt.
All right, so both this 405 and 404 collected from the shirt.
No, 40, that picture there, is that 404?
404.
404 is a control, so that's 2 things that I brought out. One is the solution to test for the gunshot residues. The other is a known particle of gunpowder. 405 were suspect particles that I tested.
All right, but they didn't actually react.
They didn't react, correct.
Gotcha. So 406, of course, is this the photo that you went ahead and looked at as part of your analysis for the muzzle to target distance? Is that what you looked at?
Appears so, yes. Like I said, it doesn't have markings on it other than the time stamp at the bottom, but that appears to be the photo that I looked at, yes.
All right. And so when we look at 407, is that consistent with what we just looked at in 406?
Yeah, that would be the same orientation of the shirt relative. This was a photo I took. That would be the same orientation of the shirt relative to the body as is the previous photo that you saw.
408, what are we looking at here with 408?
408 were 2 test fires I made. Basically wanted to see, or wanted to confirm that the rolling of the fabric wasn't caused by the blood. And so I obtained another shirt that was the same manufacturer and design, essentially the same shirt that Mr. Arbery was wearing. And I shot that 2 times just to see what that would look like.
So when you talk about a press contact, are you talking about the end of that shotgun in states 332 up against somebody?
Yes, up against the test material that I had testing there, yes.
Okay. And then near contact was further away?
It was, yeah, it was within an inch or 2. It was right there at the fabric.
And when we look here at 409, what are we looking at? Here, I'll focus it.
So that would be, yeah, I was trying to read, that would be defects under the right side and right arm. So that's on this side of the body, on the right side of the body. those were also consistent with pellet exit defects in the shirt.
All right, so when we're talking about Mr. Arbery, we've got this particular shot and this particular shot, correct?
Yes, there were 2 shots, one to the armpit, shoulder area, one to the mid-chest area.
All right, so with the one to the torso and mid-chest area, your conclusion was that it was what?
Contact or near contact.
And the one up here under the arm, your conclusion was?
The same, contact or near contact.
All right.
And that's to the fabric. You know, I'm looking at the wound, but I'm looking at examining the shirt.
Okay. So because you're looking at the fabric of the shirt.
Yes, correct.
Okay. You're not the medical examiner.
Correct.
All right. So you're not looking at the body, right?
I look at the body to assimilate the holes, but I'm making my observations and my analysis based off the shirt.
All right. And the shirt really is just how much it tore and the curling of the fabric?
The searing and the tearing and the curling and the size of the holes, yes.
Okay. And you're not able to opine as to, offer an opinion to the jury as to the order of shots?
I mean, it appears from looking at the video that I saw that the last shot was the shot to the armpit area. And it also appears that, just looking at what appears to be...
I'm sorry, I'm going to object to Mr. Leopard opining what he watched in the video, which we've all watched now a dozen times, and his coming to a conclusion where the video speaks for itself.
Yeah, it's sustained. I mean, if anything, sustained as the question's asked, yes.
Without having watched the video, would you be able to tell the order of shots?
No.
All right, so let's go ahead and talk about this particular shotgun that is within State's Exhibit 332.
Yes.
Okay, I'm actually going to ask you to come back down, sorry. And unfortunately, you took your gloves off. You got them right there? Okay. You got it?
Yes.
So, how does that shotgun work? Go ahead and pull it out so you can go ahead and show the jury.
From start to finish?
From start to finish.
Okay. So this weapon has there's 2 places that cartridges are loaded into it. One is in the tube magazine, that's this physical bottom tube here. The other is into the chamber of the weapon, which is in the top tube at the rearward most section here. So cartridges are loaded in one of those 2 ways. If they're in the tube magazine, the slide, that is this, and that will, you have to excuse me here, that will not operate with this in place. But this slide, as it is pulled rearward, will pull a cartridge out of that tube magazine, and as it is pushed forward, will load that cartridge. It will elevator it up into the top, into the chamber of the weapon. At that point, the weapon is ready to fire. There's a safety on the weapon here. As it's pushed to the right of the weapon, that would be that way, it is engaged. That means the weapon will not fire. As it's pushed to the left, that means the safety is disengaged. It's ready to fire. So assuming it is loaded and the safety is off, at this point, the only thing that happens is you pull the trigger. When the trigger is pulled, the weapon fires, okay? The cartridge stays in the chamber of the weapon. And in order to load another cartridge in there, you move the slide rearward, the slide forward. That extracts the spent cartridge and loads the next cartridge from the magazine. And at that point, it's ready to fire again.
How many cartridge cases can fit into that shotgun?
Again, can I refer to my notes for that?
Of course.
Yes. So as I tested it, the magazine would hold 6 and the chamber would hold 1. So that's 7 total.
And when this shotgun came to you, how many cartridges and cartridge cases did you get?
that were submitted?
So in the box with the weapon, there was one cartridge case and 4 12-gauge cartridges. So 1 fired and 4 unfired. Also submitted in separate packaging from that. There was my item 14 was a single 12-gauge cartridge case. My item 16 was a single 12-gauge cartridge case. Also, there was item 17, which I don't believe we've talked about yet. That was 3 12-gauge cartridges unfired. I believe that is all of the 12-gauge ammunition that I've received.
Okay, so excluding the item number 17, I think, no, I take that back. Hold on, I want to make sure I get this right. 1 cartridge case, meaning spent shell case, came with that gun.
In the box, yes.
In the box. Then you had 4 cartridges which could be fired.
Yes.
They came with that.
Yes.
All right, so that's 5. Then we have State's Exhibit 334 and 336, okay? And that makes a total of 7, is that right?
Yes.
All right. So with this particular shotgun, how do you get 7 in there?
You put 1 in the chamber and you load the other 6 in the magazine, in the tube magazine underneath.
Okay, so you got 6 in the tube magazine underneath, you load 1 in.
Yes.
Okay. Once that one is loaded in, what do you have to do to fire it?
You have to disengage the safety and pull the trigger.
That's all you have to do.
Yes. By assuming, and I say that assuming by loaded, you mean that the cartridge is in the chamber and the slide is forward. Safety off, pull trigger, fire weapon.
Okay, so let's say, for instance, there's 7 in there, and I take the safety off, and then I go ching ching. What's going to happen?
You're going to eject the first one that's in the chamber. You're going to load the next one that is in. I'm sorry. Yes, you're going to load the next one that's in the magazine, assuming it functions correctly.
Okay, so if this shotgun already has 6 in and 1 in the chamber, I just take the safety off and pull the trigger.
Yes.
Now, in order to fire it, the next time.
One thing there to clarify too.
Yeah, go ahead.
Your question about extracting that first cartridge. Okay, so there is a lever, I think it's called a slide lever lock. It's on the side of the weapon. Once the slide is forward and it's loaded, that lever has to be pushed to unlock that slide unless you pull the trigger. So I don't know exactly what your question was there, but in order to take that one out, you would have to unlock the slide with that button, that lever.
So for instance, I loaded the shotgun, I had the 6 below and the 1 in here, in the top, the 7th one. If I just wanted to take it out without having to fire the gun, I'd have to hit the lever.
Yes.
So that's me, basically if I just wanted to unload the gun at that point.
Correct.
Okay, but if I am about to fire the gun, I've got the gun, I just hit the safety and I can pull the trigger, will anything eject at that point?
No.
Why not?
Because you will have to manually pull the slide rearward to extract and eject the spent cartridge and then push it forward to load the next cartridge into the chamber.
So if I have fired it once, I have to ching ching, and then a cartridge goes this way. I know I'm making noises, but cartridge goes this way.
Yes.
I'm ready to fire again.
Yes.
I pull the trigger again. What happens?
The weapon should fire.
Is the cartridge going to eject?
No, it will stay in the weapon.
Until
Same
what?
cycle of order there. You would have to extract and eject by moving the slide rearward and forward.
And I fire it a 3rd time, what happens next?
Same situation. Slide rearward, slide forward.
Do you know how much pressure is needed to pull the trigger on that particular shotgun?
That is something I tested, yes.
And what was that?
I tested it 3 times, and it was an average of 3 1/4, 3.25 pounds.
3.25 pounds of pressure.
Yes.
Let me have one moment. I want to make sure I've covered everything. Oh, of course I have not. I'm going to ask you, did you measure that shotgun? And if not, can we measure it now?
We can, yes.
All right.
Did I measure? I guess that was your first question.
Well, as part of your analysis, did you actually measure the shotgun when you first did your analysis back in June of 2020?
Yes. The main thing we're looking for there is to determine if the barrel of the shotgun is of legal length and if the overall length of the shotgun is of legal length. For shotgun, per federal statutes, the barrel length has to be at least 18 inches or longer. Overall length of the shotgun has to be at least 26 inches or longer. So we're just looking to see if it's longer than that.
And was this of legal length?
Yes.
All right. So what I'd like to ask you to do is come on down and measure the shotgun.
So I'm measuring from the butt of the shotgun, that's the rearwardmost point, and to the end of the barrel is just shy, I would say 38 3/4 of an inch. Just shy of 39 inches.
Okay. And how long, well, first off, when you go ahead and fire the shotgun, go ahead, if you don't mind, just sort of hold it in a manner that you might hold it to fire a shotgun, maybe up against your shoulder.
Okay.
And please don't point it at anyone. That way. All right, that way. So you put it up against your shoulder.
Yes.
And you hold it. Your finger is there.
Yes.
Okay. So normally, where would you put your left hand? Where it is right now?
Where it is right now, yes.
Okay. So I'm going to ask you to hold it like that. From here to here is, well, you can't see that. From here to here is how long? Basically where the pull is.
To the trigger is about 25 inches.
About 25 inches. Okay. Now, are there other ways to carry and fire a shotgun other than just up against your shoulder like that?
Sure. I mean, that would be what we would call the normal shooting position. That's with the weapon up like this, with the rear of the gun against your shoulder, sort of in the crease of your shoulder, like this. It could be held unlimited ways, basically. Okay. As long as your finger can reach the trigger, and as long as you have something supporting it reasonably here on the forend.
Got it. Thank you very much. Your Honor, I believe at this time, I will go ahead and pass the witness. Thank you.
Good afternoon, Agent. Is Agent Leopard?
No, I'm a civilian. I'm just a crime lab scientist.
Okay. Science is Leopard.
Sure.
Excuse me. Mr. Leopard, my name is Paul Rubin. I represent Travis Big Michael, and you and I have spoken before.
Yes, sir.
We spoke about, it's November, 2 months ago?
That sounds about right, yes.
Okay. And we talked about some of your findings in the case, correct?
We did.
Specifically, the muzzle to target examination that you did?
Yes.
Okay. But let me go backwards in time a little bit. You first, well, let me go even further back. When you, as a crime lab examiner, complete your examination, you complete a report.
Yes.
Has a case number, right?
Correct.
Has your name on it.
Yes.
It has your signature on it.
Correct.
It has a list of the items received or evidence received.
Yes.
And it has your conclusions or results.
Correct.
And you do that in every case in which you are asked to conduct an examination.
Yes.
Okay. Within the report is a report date, right?
Yes.
How soon after your examination do you do a report date?
It just depends upon the case. Sometimes it takes a bit of time to after the examination to wrap up all the paperwork. If the case is a situation where it's verified, microscopic work, it's verified by a second examiner, and then peer reviewed, it just that time varies.
Okay, so you don't have an official report until you've done your examination and your examination results have been and methods have been reviewed by another peer in your agency.
Correct. All those things are done and released, and that's the report date.
Okay. Do you have your reports with you?
Yes.
Okay. There's a case number which the state has asked you about, and it's 2020-600-1183. That's the case number for this particular case.
Correct.
And it's specific only to this case. There's no other cases that have that case number.
Correct.
Now, you received evidence in this case as far back as, and if I'm reading this correctly, February 25th, 2020. And that would be the report where there's a whole lot of items received.
That is the farthest back date, I believe, yes.
Okay. Now, those items are not given directly to you. They're put in a lockbox.
Correct. They're entered in, like I spoke before, they're put in a lockbox, and then they're kept under secure access until at which time they're returned.
Okay. And even though they're delivered to you on February 25th, you may not get to your examination for some weeks or months later, depending on your caseload.
That's reasonable, yes.
Okay. In this case, the items were delivered, and we're talking about items such as the 12-gauge cartridge cases, the wadding, pellets that you testified about, the 357 Magnum revolver. You got those on the 25th, but your report, your final report is dated June 10th, 2020.
Correct.
So it took, I don't know, 5 months or so, 4.5 months for you to get to the items, examine them, do all the analysis, and then have it peer reviewed, and then a final report.
Give or take that timeline, yes.
Okay. You have a second report in which you've testified about this as well, in which you...
I'm going to...
Oh, I'm sorry. Didn't mean to do that. You have a second report in which you received items in May of 2020, May 11th, and the items you received were the Remington 12-gauge shotgun, right?
Yes.
And 12-gauge cartridge case and cartridges.
Correct.
And you turned that around and wrote a report even earlier than your other report. Your report is dated 5/21/2020.
Correct.
Okay. And you've testified to the items you reviewed, what your conclusions were about the cartridges and the shotgun, the unfired cartridges, your examination that the shotgun itself was functional. All of those things you did in those two reports, covered those things.
Yes, I did.
Okay. It wasn't until a year later that you were asked to examine the T-shirt, right?
That was in 2021, yes.
2021. Who asked you to examine the T-shirt?
That was at the request of the Cobb County DA's office.
The people at this table?
Yes.
Their office.
Their office, yes.
Not the medical examiner, right?
Correct.
Not GBI agent in charge, Richard Dial.
Not at that timeline, no.
Okay. So at that time, you were asked to determine the muzzle to target distance because it had not been determined yet.
Correct.
Okay. Did you ever speak to a former GBI agent named Jay Jarvis?
Spoke to him, yes, a few, I'm going to say 2-ish months ago, 3 months ago, somewhere in that timeline.
Around the time that we spoke?
Yes.
Okay. And do you know who he was?
Yes.
And who do you know him to be?
He's an outside independent expert in firearms.
Okay. And did he call you?
I object to relevancy as to an outside expert having anything to do with this.
It goes to the timing of why he examined this clothing in June of 2021, as opposed to doing it back in May of 2020 or June of 2020 when the case first came in his office.
And I believe he's already testified that we asked him to do it. So I'm not sure where we're going with relevancy here.
I'll move on.
Okay, yeah, that's
Okay.
sustained.
Mr. Leopard, so we spoke in September of 2021. You had completed your analysis in June of 2021.
Yes.
And your results were that the hole in the t-shirt in the left armpit area, upper shoulder, and the hole in the t-shirt or holes in the t-shirt in the center midline of the chest were caused by shotgun blasts from a contact or near contact wound.
Yes.
And you've described for the jury that contact pressing against it, right?
Correct.
And near contact sounds like from what you testified to is an inch or two at the most.
It's very close. I wouldn't put a definite number on it just to say, you know, I would just say that it's got to be close enough for that gas exiting the end of the gun to make an impact on the fabric to cause that searing and tearing and rolling back as we saw.
Okay. And the gun itself, the barrel of the gun, you said was 18 inches.
Approximately, a little more. 18 inches is the cutoff to be legal, so it was just slightly more than that.
Slightly more than that, okay. I certainly don't want to handle that gun, and no one wants me to handle that gun. Do you mind stepping down if it's okay with the court and picking the shotgun up?
Do you have another set of gloves?
If you'll just point it just at the wood, okay, right there. Contact, near contact wound. If the wood were the t-shirt that you've described, could you show the jury how close that gun would be to that t-shirt?
Yeah, and again, this would be an approximation. Obviously, contact is touching the wood. Near contact, it's going to be close. I don't have an exact number. You know, as it were, it's just an approximation. But it's going to be close to the wood, close to the shirt.
Okay. Thank you very much. You can put it down.
Put it down.
Please have a seat.
Okay.
Were you ever asked to submit that shotgun to another department within the GBI crime lab, the fingerprint department?
No, fingerprints would happen before I received the shotgun, and to my knowledge, I'm not going to say fingerprints weren't done, but they would have been done before me, so that would have been taken care of before I got the shotgun.
And you were not made aware of any fingerprint results as, from an examination of that shotgun?
There are none that I know of. There could have been, but I'm not aware of it.
Okay. Based on your analysis of the shirt that you received from the medical examiner's office, the shotgun was clearly within arm's reach of whoever, Mr. Arbery in this case, was on the receiving end of a shotgun blast.
Objection calls for speculation as to whether that shotgun was within arm's reach.
I don't think it does, based on his testimony. Can you answer that question without speculating?
I mean, I think it's reasonable to say that if the end of the shotgun can touch your shirt, if you are the victim, then it would be reasonable to think that you can also grab the shotgun. Is that answering your question?
It sure does. Thank you, sir. That's all I have, Your Honor.
Anything from Greg McMichael?
No, Your Honor.
From Mr. Bryan?
No, Your Honor.
Any redirect?
Just a few questions. So I'm going to take a look at your report. I just want to clear this up. On February 25th, 2020, what exactly did you receive?
So on February 25th, that would be the items from, yes, that would be the items from the medical examiner, both the pellets and wadding that we spoke of, as well as the clothing.
Okay.
Those were all received, and by me, those were received into the lab on that date.
Okay. So the medical examiner's offices, or how close are they to your offices?
So we're in the same building. They're a separate section, but we're in the same building.
So you guys are in the same building?
Yes.
Okay. So, but you're following procedure because you got to mark everything, right?
Yeah, as we treat them as a submitting agency, we treat them as a submitting agency just like we would treat any other agency. So they bring items over, they put them in lockbox or hand deliver them to another scientist or to another, evidence receiving technician, and they're treated the same way.
All right, so when we're talking about that, what we're talking about is State's Exhibit 343 and 342.
The autopsy stuff, yes.
Autopsy stuff. Okay. So, moving down that particular page, when did you receive from GBI Region 14 Kingsland the actual shotgun itself? 332.
The shotgun was received May 11th of 2020.
All right. And then, when did you receive the handgun, the Smith & Wesson 357, which is States 339? When did you receive that?
That was received May 22nd of 2020.
And States Exhibits 336, 334, and 335. When did you receive these?
Those are all of the cartridge cases, items from GBI Region 14. That would be the same date, May 22nd of 2020.
So May 22nd is when you received all of this stuff.
Yes.
And so then your report was June 10th of 2020.
Sorry, that report. Yes, that report was issued June 10th of 2020.
All right. And who's the person who called you up and asked you to do the muzzle to target analysis?
It was your office.
Okay. Was it me?
I believe it was you. It was someone from your. It was either yourself or someone previous to you.
Okay. All right. Anything else? No. Thank you very much.
Anything in those matters?
Yes. Do you know why Ms. Donikoski called you to do the muzzle to target distance?
It was my knowledge that they wanted it done just for the completion of the case, the totality of the case. So that was what I think she and we decided was the best thing for the evidence.
Any reason it wasn't done earlier, do you know?
It was asked earlier, but earlier on in the case, it was asked by a GBI agent way earlier in the case. And a muzzle to target is not a service that we typically just do on every case. It's only done on an as-needed basis, and typically it's on an as-prosecuted basis. So a lot of times it will not be done until the prosecutor asks it because one was the video and the case was evident, and that was asked by her at a later date, and we decided that if that was what she needed to prosecute the case, that was what would be done.
Do you know if the medical examiner came to a conclusion after his autopsy of a muzzle to target distance based on what he had at that time?
I'm going to object to the ME is about to testify next, so him testifying to what the ME said or did at any time.
I have not asked him what the ME said. I just want to know if he knows if the ME did a muzzle to target distance, not what the answer is, not what he said or anything. Do you?
So rule. Go ahead.
Okay. Do you know? Do you know if the medical examiner did a muzzle to target examination as part of his autopsy?
I don't think he did a muzzle to target examination per se. I think he may have had an opinion on distance.
Okay. Do the elevators work in your building?
Yes.
Were the elevators working back in June of 2020, July of 2020, August of 2020, all the way to June of 2021?
I'm sure they were, yes.
Any reason the medical examiner couldn't come to you and bring you that white T-shirt?
That would be up to him.
Okay. Thank you, Mr. Leopard.
Thank you. You can step down. You are released for the day, but subject to recall. Thank you. Let me see counsel briefly. All right, ladies and gentlemen, we are at a good breaking point for the day. We're going to go ahead and adjourn until 9 o'clock tomorrow morning. Again, going to give you the same instructions. Do not discuss this case amongst yourselves or with anybody else. Don't go looking for any information about the case, and if anybody approaches you about the case, please notify the court immediately upon your return and do not discuss that with your fellow jurors. So again, don't go looking for any information. Don't go picking up the news or news feeds or social media or whatever's out there. If anybody's talking about this case around you, you need to walk away. Make sure that you do not spend any time around anybody who is talking about the case in your presence of hearing. With those instructions and all of the other instructions I've given you, thank you again for your attention today. It is greatly appreciated on behalf of the Superior Court of Glenn County. Have a good evening, and we'll see you back tomorrow morning.
All rise for the jury.
All right, anything from the state before we recess?
No, Judge.
From Travis, you said that with some trepidation. I was wondering where that was going. Anything from Travis McMichael?
No, Your Honor.
From Greg McMichael?
No, Your Honor.
From Mr. Brown?
Your Honor, for the record, I had hoped to hear something back from the court after the remarks made this morning.
Hope to hear something back from the court on what?
All right, Your Honor, I have nothing further at this time.
I'm confused. What are you waiting for, Mr. Goff?
I was expecting the court to address the remarks the court made this morning. Obviously, I was mistaken. I stand corrected, Your Honor. I have nothing else today.
We're in recess.